For the lead attorney or captain for the prosecution, do you have any conflicts with regard to the panel?
No, Your Honor, the people have no conflicts.
And the defense, do you have any conflicts?
No, Your Honor, the defense has no conflicts.
Thank you. So first of all, again, welcome to the competition. I'd like to get started with the swearing in, and then we will do introductions. So first of all, I'd like to swear in the team members. So all the team members, turn on your videos and raise your right hand. I know that this is a virtual platform, but I like to see that. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes,
Yes, Your Honor.
Thank you. Witnesses, please raise your right hand. Thank you. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes,
Yes,
Your
Your
Honor.
Honor.
Obviously, normally we would ask that the gallery members who we would be seeing today, we don't get to see them, but I also like to have the gallery members, even they're seeing this virtually, also raise their right hand. And I'd like to ask them, gallery members, including teachers and attorney coaches, family members and friends, please raise your right hand. And do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after the mock trial round? And I am going to assume everybody says yes. Now, scoring panelists, could you please turn on your videos again and raise your right hand? I'm only seeing two panelists here. Where is my other panelist? Okay,
She was
maybe
here earlier.
I agree. So I'm worried about that. Oh, Carolyn. I think Carolyn is my third panelist here.
I had it on mute. I'm sorry.
Not a problem. Okay, so scoring panelists, please raise your right hand. And I'm assuming Carolyn, oh, there you are. Okay,
I got it back.
thank you. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
I do.
I do.
Thank you. You may go ahead and turn off your videos. Now, I'd like to start with introductions with the prosecution first. Who would like to start introductions?
I can, Your Honor.
Go ahead, Ms. Seaman.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Anna Seaman, and today with my co-counsel, we represent the people of the state of Colorado versus Avery Becker. Today, I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Avery Becker, as well as delivering the closing arguments. May my co-counsel introduce themselves at this time?
Yes, please do.
Good afternoon. My name is Leah Dino. I will be conducting the direct examination of Alex C. Fuentes and the cross-examination of Taylor Perkins.
Good afternoon. My name is
Thank you.
Thomas Vanessa. I will be giving the opening statement for today's trial, delivering the cross-examination of Professor Blake Van Owen, as well as directing Mr. Kyle Cusack. At this time, may our witnesses introduce themselves?
Yes, please do. Thank you, Mr. Neeson.
Good afternoon. My name is Dirksen Brinkerhoff, and today I am Detective Jordan Markowitz.
Good afternoon. My name is Owen Hallbrook, and I am Alex Cifuentes.
Thank you.
Good afternoon. My name is Michael Dudzik, and I am Kyle Kuzak. Thank you, Your Honor.
Thank you. Would the defense please introduce themselves?
Yes, Your Honor. Good afternoon. My name is Kate Malloy, and I will be presenting the opening statement, as well as conducting the cross-examination of Detective Jordan Markowitz and the direct examination of Taylor Perkins.
Thank you, Ms. Malloy.
Good afternoon. My name is Bridget Carrington. I will be conducting the cross-examination of Alex Cifuentes and the direct examination of Avery Becker.
Thank you, Ms. Carrington.
Good afternoon. My name is Pilar Melendez, and I will be conducting the cross-examination of Kyle Kuzak, the direct examination of Professor Blake Van Owen, and delivering the closing argument. May our witnesses introduce themselves?
Yes, Ms. Melendez, thank you.
Good afternoon. My name is Caitlin Brennan, and I am Professor Blake Van Owen.
Thank you, Ms. Brennan.
Good afternoon. My name is Annika Buchin, and I am Taylor Perkins.
Thank you, Ms. Muchin.
Good afternoon. My name is Hannah Feeney, and I am Avery Becker.
Thank you, Ms. Feeney. Is the prosecution ready to start the trial?
Yes, Your Honor. We have a few preliminary matters that we would like to bring forth to the court.
Absolutely. Go ahead and proceed.
Yes, Your Honor. First, we request that the stipulated facts be entered into evidence and constructively read into the record.
So granted.
We would also like to confirm the screen sharing process. What we have done in the past is once the exhibit is mentioned, we bring it up on the screen and it is not effectively shown to the jury until it is entered into evidence. And we would like to confirm that that is an okay process for the court.
It is.
And finally, the people request that any remaining time on closing be reserved for rebuttal.
It'll be reserved. Thank you.
No further from the. Thank you.
Does the defense have any preliminary matters to address?
Yes, Your Honor. First,
Proceed.
we would like to let the record reflect that a copy of our trial roster has been put in the chat, as well as the pronouns of all of our witnesses. And the trial roster is available for download for all of the scoring members of the jury.
It has been, and I myself have downloaded it. It's very clear. I don't see any problems with it.
Yes, Your Honor. Next, the defense will also be following special rules for the admission of exhibits like prosecution pursuant to Rule 7.4 of the Rules of Competition.
Not a problem.
And Your Honor, since the exhibits will be displayed on the screen for purposes of identification and they will be considered shown outside the presence of the jury, would Your Honor prefer for us to ask for permission to display those exhibits or simply let the record reflect as such?
I would prefer that you request permission.
Yes, Your Honor. Additionally, Your Honor, while each of the members of the defense team have made efforts to be in settings with the best possible internet connection, if at any point you cannot see or hear us, please feel free to let us know.
I will do that. And I have had experience with that happening at the regionals where video went out, but we were able to communicate by texting. So we got the trial back on track. I don't expect any problems today.
Yes, Your Honor. Next, can the court clarify as to whether it intends to constructively read the jury instructions prior to or after closing argument?
We will be not reading the jury instructions at this time.
Yes, Your Honor. In that case, may we have permission to refer to the jury instructions in our closing argument?
You may.
Lastly, I would just like to confirm for the court and the jury that all complaint information stipulations and all preliminary matters have been incorporated into the record at this time.
They have.
Based on that, Your Honor, the defense is prepared to proceed with opening statements.
Thank you, counsel. So Ms. Seaman, Are you ready to proceed with opening statements?
Yes, Your Honor.
May I proceed, Your Honor?
Right. I apologize. I got the wrong name. I'll
No.
get it right. Mr. Denisa, please proceed.
Everyone has a breaking point. And we are here today because the defendant, Avery Becker, reached hers. And on March 6th, 2020, Ms. Becker broke into the home of Mackenzie Brackman and in a struggle, stabbed and killed him. My name is Thomas Denessa, and along with my co-counsel, we represent the people of the state of Colorado. First, let's meet Mr. Brackman, an attorney well known in the Denver community. Not only was he a respected member of the bar, but he also encouraged the next generation of lawyers by coaching the mock trial team at Colorado High School. And one of those best upcoming lawyers on the team, Avery Becker. Although the defendant will tell you how she cherished mock trial, her peers, Alex Cifuentes and Taylor Perkins, will tell you how the defendant's lazy attitude fractured her relationship with Coach Brackman. And Coach Brackman called the defendant out on this lack of commitment before the whole team just after regionals last year. The rift between them exploded. Following the confrontation, you will hear how seething with rage, the defendant sprinted out of practice and with a Sharpie, vandalized Coach Brackman's vintage Porsche 911. Unfortunately, Coach Brackman kicked the defendant off the team. Immediately after that, the defendant herself will tell you how she went home and to her mother said, and quote, that she would get back at Brackman if it were the last thing she did. The defendant repeated this threat to her mock trial teammate, Alex Cifuentes, who will also tell you about the text message he received from the defendant shortly thereafter, stating that the defendant planned to get revenge against Coach Brackman by waiting until he was at work, breaking into his home, and trashing it. And on March 6th, 2020, the evidence will show that the defendant did just that and more. Because as it turned out, Coach Brackman wasn't at work. He was at home. Detective Jordan Markowitz of the Denver Police Department will tell you that Coach Brackman's Ring doorbell alerted him of an intruder prowling outside of his home. So Mr. Brackman armed himself with a knife, only to lose that knife and his life in an altercation with the intruder. Detective Markowitz will explain how he collected electronic evidence, not only from the Ring doorbell system, but also from the defendant's cell phone. His analysis of the defendant's call records and location data from March 6th demonstrates the defendant's movements away from school, away from her house, and towards the home of Mackenzie Brackman, right before the murder. Now, the defendant will try to explain away her movements that day by claiming to have lost her phone, and that someone else must have had it. But the defendant only has one person who can corroborate this story, her best friend, Taylor Perkins. The same Taylor Perkins who will tell you how she ditched school on March 6th just to help her friend find her phone, and who got together with the defendant 2 times after Coach Brackman died, before either was interviewed by the Denver Police Department. Now, although the defendant's expert, Professor Blake Van Owen, who, mind you, never visited the scene of the crime, will try to paint a picture that the intruder startled Coach Brackman and stabbed him while he was seated. Those pieces just don't fit the puzzle that Kyle Kuzak, a crime scene reconstructionist for the Denver Police Department, solved. Investigator Kuzak will connect together each piece of evidence that Detective Markowitz collected. The scuff marks by the door, the shattered plate, the open drawer, along with the coroner's report detailing the knife angle to conclude the defendant stabbed Coach Brackman in a bear hug manner following a struggle. The prosecution has charged Avery Becker with second-degree burglary and first-degree murder. You may have heard this combination of crimes called the felony murder rule. This means when the defendant killed Coach Brackman during the break-in, and the defendant can be found guilty not only of breaking in, but also murder. Following this trial, you will hear jury instruction number 8. That states the defendant need not have any intent to murder Coach Brackman, but simply the intent to commit a crime after knowingly breaking into the home of Mackenzie Brackman. The evidence will show that intent beyond a reasonable doubt. Avery Becker had reached her breaking point. Following the evidence today, the people will ask that you find the defendant, Avery Becker, guilty of second-degree burglary and first-degree murder. Thank you.
Thank you, Mr. Denisa. Ms. Malloy?
Yes, Your Honor. May it please the court? The prosecution just told you their version of what they are alleging took place on March 6, 2020. Did you hear that? They can't actually prove that Avery Becker is guilty. And today, you will learn why. Avery Becker has an alibi. Blair Rollins is the alternate suspect, and the prosecution conducted an awful investigation. Alibi, alternate suspect, awful investigation. The prosecution wants you to believe that Avery Becker, a teenager who just wanted to get back on her mock trial team, planned to break in and trash her coach's home. They want you to believe that Avery Becker somehow disarmed her coach, and while they were facing each other, she somehow proceeded to stab him in the back. The prosecution expects you to believe that Avery Becker is guilty, despite there being no physical evidence linking her to the scene of the crime. How can we know what really happened? Well, when it comes to Avery Becker, the truth lies in the alibi, the alternate suspect, and the awful investigation. As you listen to the prosecution's evidence today, ask yourselves these 3 questions. First, what time did the victim actually pass away? Second, where has Blair Rollins been since March 6, 2020? And third, how can someone be in 2 places at once? But remember, at the end of the day, we don't have to prove the prosecution is wrong. They have to prove they are right, because the prosecution has the burden of proof in today's case, which means they must prove each and every element of every charge to you beyond a reasonable doubt. That means that if the prosecution's evidence makes you hesitate, leaves your minds wavering, unsettled, or unsatisfied, they have failed to meet their burden and you cannot convict. Remember the alibi, alternate suspect, and awful investigation. Now let's break that down and start with the awful investigation. The prosecution just made you a lot of promises about what Detective Markowitz and Kyle Kuzak will tell you today. Hold them to those promises. And you don't have to take just my word for it. Today, you will hear from Professor Blake Van Owen. Professor Van Owen will tell you all about the prosecution's assumptions and incompetence. You will learn that the prosecution's theory is like a house of cards. If one falls, so do the rest. The truth is, the prosecution's star witness, Alex Cifuentes, could be completely framing Avery Becker, and we will never know because the prosecution's awful investigation never looked into any alternate suspects. So next, let's talk about the alibi. Avery Becker couldn't have committed this crime. We know this because she was in a public place with Taylor Perkins all day on March 6, 2020. But again, you don't have to take my word for it. Today, you will hear from Taylor Perkins herself. She will tell you how she and Miss Becker spent the day looking for Miss Becker's stolen phone. Last, let's talk about the alternate suspect, Blair Rollins. Today, you'll hear all about Blair Rollins, but you won't actually hear from Blair Rollins. And that is because the prosecution's awful investigation never looked into Blair Rollins. Now, despite that, you will learn that Blair Rollins matches the height and build of the suspect. You will learn that Blair Rollins had a motive to kill Mackenzie Brackman. And you will learn that Blair Rollins has not been seen since March 6, 2020. Last, you will hear from Avery Becker herself. Miss Becker did not have to testify today. She is choosing to waive her constitutional right not to testify, to come here, look each of you in the eyes, and tell you what really happened. The prosecution is right. Everyone has a breaking point. And Blair Rollin reached her breaking point when her father was convicted under Mr. Brackman's defense. Avery Becker did not commit this crime. This we know because of the alibi, the alternate suspect, and the awful investigation. If you hold the prosecution to their burden, I am confident that at the end of this case, you'll return with the only just verdict, not guilty. Thank you.
Thank you, Ms. Malloy. Is the prosecution ready to start their case in chief?
Yes, Your Honor. The people call Detective Jordan Markowitz.
Thank you.
May I proceed?
Yes, you may.
Good afternoon, Detective Markowitz. Please state your name and spell your last name for the record.
Yes, Jordan Markowitz, Markowitz.
And what do you do for a living?
Well, I'm a homicide detective for the Denver Police Department.
How long have you been working there?
I've been working for the DPD for around 13 years, but I've been a homicide detective for 7.
Do you have any other certifications?
I do. I have a certification in cell phone technology and forensic data reconstruction from the American Academy of Law Enforcement.
How did you obtain this?
Well, I took a 3-day training course and then completed a high-level certification test.
Do you have any experience in cell phone recovery?
I do. I've worked with cell phone recovery, specifically call detail records and the Cellubrite system recovery software in over 50 cases of detective casework.
How are you involved in the case today?
I was the leading homicide detective.
Were you asked to give an expert opinion?
I was.
Your Honor, the people offer Detective Jordan Markowitz as an expert in crime scene investigation, cell phone technology, and data recovery pursuant to Rule 702.
Any objections to this witness and his qualifications?
Could Your Honor ask opposing counsel to clarify what the qualifications are?
I think that counsel has already brought those up.
Yes, Your Honor. I have no objections if that is the case.
Thank you, counsel. Go ahead and proceed.
Yes, Your Honor. Now, Detective Markowitz, did you come to an expert opinion in today's case?
I did. It is my expert opinion that the defendant in this case, Mr. Avery Becker, went to Mackenzie Brackman's house on March 6th.
I have an objection, Your Honor. May I be heard?
Yes, go ahead.
I would object opinion before facts, Your Honor. The detective is testifying to the opinion that he came to in today's case without laying any foundation as to the facts that caused him to come to this conclusion.
Any response?
Yes, Your Honor. Pursuant to Rule 705, an expert may state and give reason for it without first testifying to the underlying facts or data.
May I have a moment? Oh, sorry.
Go ahead. Did you have a reply?
Yes, Your Honor. May I have a moment to consult the rules?
Yes.
Yes, Your Honor. Rule 705 says that an expert may state an opinion and give the reason for it without first testifying to the underlying facts or data, unless the court orders otherwise. In this case, the court should order otherwise, as this is more prejudicial than probative. The jury does not know what caused the detective to come to his conclusions in today's case, and therefore it would cause the jury to be overly prejudiced against my client in today's case.
The objection is overruled. You may proceed, Ms. Seaman.
Yes, Your Honor. Detective Markowitz, can you please continue with your opinion?
Absolutely. It is my expert opinion that the defendant in this case, Mr. Avery Becker, went to Mackenzie Brackman's house on March 6th in 2020 and killed Mr. Brackman.
How did you first become involved in this case?
Well, on March 6th, 2020, a passing motorist, no name, reported seeing a passed out body on the porch of 444 South Flower Street.
What did you observe when you came to the house?
Upon entering the scene, I noticed that the recently deceased Mr. Brackman was just inside of the house, just inside of the front door, which I thought was odd because the passing motorist reported the dead body on the porch.
And did you review the body when you got there?
I did. And upon seeing the victim's ID, I could recognize the victim as Mr. Brackman.
Would you recognize an image of the body if it were shown to you?
Yes.
Your Honor, permission to screen share Exhibit 2.
You may proceed.
Detective Markowitz, what is this?
Well, specifically, this is a picture of the victim's body. It is a bird's eye view of the victim's position where he fell, and also the stab wound and the pool of blood just below his left shoulder.
Is this a fair and accurate depiction of the way you saw the body at the crime scene?
It is.
Your Honor, the people offer Exhibit 2.
Any objections?
I have no objection, Your Honor.
The exhibit will be so published to the jury.
Detective Markowitz, what could you conclude based on the position of this body?
Well, based on the outward position of the body and the fact that the victim was directly next to the front door led me to believe that Mr. Brackman was likely stabbed within the interior of the home and attempted to flee the scene. However, he collapsed before he was able to do so.
Did you observe the weapon of attack?
I did. The weapon of attack was a large chef's knife next to the victim's body.
After reviewing the body, where did you go?
Next, I walked around the exterior of Mr. Brackman's house.
What did you see there?
I saw 3 different Ring doorbell security cameras.
Did you review the footage from these cameras?
Yes, after downloading the contents of Mr. Brackman's phone, I reviewed 4 different videos of the perpetrator on March 6th of 2020.
Your Honor, permission to screen share Exhibit 12.
You may proceed.
Can you explain what this is, Detective Markowitz?
Yes, as we can see, the intruder is opening the back door of the house and waltzing in, as I like to say. Yes.
Is this a fair and accurate depiction of the video you reviewed?
It is.
Your Honor, the people move to enter Exhibit 12.
Any objections to the admission of this video?
No, Your Honor.
The video will be published to the jury.
And after reviewing this video, where did you go next?
Well, next I entered the same door of the house via the back door of the home and into the living room of Mr. Brackman's house.
What was the condition of the house?
Well, the house was in slight disarray, specifically in the living room. There was a toppled over chair and a broken plate on the floor. In the kitchen, there was an open knife drawer and a missing slot in a nearby knife block.
Was there blood at the crime scene?
There was droplets of blood leaving from the kitchen/living room area to the victim's body via the front door.
After reviewing all of the evidence of the crime scene, could you conclude what happened?
Yes, it is my opinion that Mr. Brackman was alerted of the intruder's presence, either from the video security system or from the intruder just blatantly walking in to the house, obviously making a fair amount of noise. Mr. Brackman then armed himself with a large chef knife from his kitchen and approached the intruder. The two then got into some sort of scuffle. The intruder got a hold of the large chef knife and somehow stabbed Mr. Brackman in the back. Mr. Brackman then tried to flee the scene. However, he collapsed face down in a pool of blood before he was able to do so.
Talk about the rest of your investigation. What did you review next?
Well, Next, I turned to the evidence, as I always do, and I went back to the contents of Mr. Brackman's phone.
What did you see there?
Here I saw copious amounts of emails and text messages that related to Mr. Brackman's involvement in the Colorado High School mock trial team.
Did you contact any students from that team?
I did. Upon obtaining a list from Colorado High School of all of the students that Mr. Brackman coached, I contacted Alex Cifuentes.
What did you learn from Mr. Cifuentes?
Well, I learned that there was a possible threat against Mr. Brackman and his home.
Did you learn who that threat came from?
Yes, this threat came from the defendant in this case, Mr. Avery Becker.
Do you know how this conversation took place?
I do. Upon interviewing Mr. Cifuentes, I asked him to send me screenshots of the text message that took place.
Your Honor, permission to screen share Exhibit 14.
Proceed.
What is this exhibit?
Well, these are the screenshots that Mr. Cifuentes sent me.
Is this a fair and accurate depiction of the copy of that conversation that you received?
Yes, it is.
Your Honor, the people move to enter Exhibit 14.
Any objection?
Yes, Your Honor. Your Honor, this is hearsay pursuant to Rule 801. These texts are being offered to prove the truth of the matter asserted, which is that Avery Becker intended to break into and vandalize Mr. Brackman's home. In addition, this testimony and these exhibits are more prejudicial than probative pursuant to Rule 403, as there has been no sufficient proof offered that these texts did in fact come from Avery Becker. It is the defense's theory of the case that Avery Becker did not in fact send these texts. As an offer of proof, I anticipate that several of the defense witnesses will testify that Avery Becker's phone was lost or stolen, and therefore it would be impossible for the text to have come from Avery Becker. The prosecution has not laid enough foundation pursuant to Rule 701 that these text messages came from Becker. And since opposing counsel has failed to lay this foundation, and Ms. Becker is contesting the validity of those texts, they are substantially more prejudicial than probative, as the jury has only the detective's word to rely upon that these exhibits are actually from Avery Becker. Furthermore, any foundation that the defense could lay would be hearsay pursuant to Rule 801, as anything Detective Markowitz knows about these text messages, he learned from Alex Cifuentes. And they would be offering them to prove the validity of those text messages, which makes it inadmissible under Rule 801. Additionally, Your Honor, pursuant to Rule 901, in order to authenticate a piece of evidence, the proponent must admit sufficient evidence to prove that this is what the proponent claims it to be. And in this case, there has been no such evidence presented that these texts are from Avery Becker. Therefore, it does not meet the requirements under Rule 901.
Ms. Seaman, any reply?
Yes, Your Honor, I will take the objections one at a time. First, to the hearsay objection, under Rule 801D2, these are not hearsay as they are admission by the party opponent. Avery Becker is responding in this case. The statements made by Mr. Cifuentes are also not hearsay under Rule 801C2 as they are not being used for the truth of the matter asserted. Rather, they're going to show the effect on the listener or the reader, in this case, Ms. Becker. In response to the more prejudicial than probative, pursuant to Rule 403, evidence probative value has to be substantially outweighed by the danger of unfair prejudice. In this case, the probative value of showing these text messages and what Avery said is not outweighed by unfair prejudice and will not cause the jury to make a decision on an unfair or on an emotional bias. It is the prosecution's theory that Ms. Becker sent these text messages and is denying these because they go against her, but rather she did send these. Later on, you will hear from Mr. Cifuentes, who will testify about the validity of these text messages and that he received these from Ms. Becker, similar to what Detective Markowitz heard from Mr. Cifuentes during their conversation. And in response to the authentication objection, pursuant to Rule 901B1, a piece of evidence may be authenticated if a witness with knowledge can authenticate it. In this case, Detective Markowitz has knowledge of these text messages. He talked to Mr. Cifuentes in an interview, and he received screenshots of these text messages, and therefore can authenticate them as accurate. And therefore, these are authentic, they are not more prejudicial than probative, and they are not hearsay.
May I respond briefly, Your Honor?
Very briefly.
Your Honor, as to the response to hearsay pursuant to Rule 801D2, again, prosecution has not laid enough evidence that the detective knows that these were from Avery Becker, and any evidence that they would lay would also be inadmissible under Rule 801 as he did hear it from Alex Cifuentes. Furthermore, Detective Markowitz does not have sufficient knowledge to authenticate these documents, as on cross-examination, I anticipate Detective Markowitz will say that he never got the Cellbrite data or corroborated that this was in fact Avery Becker's phone number at all. So all he is going off of is Alex Cifuentes' word, and this is not sufficient to validate this exhibit under Rule 901.
Thank you, counsel. The exhibit will not be admitted into evidence at this time, but certainly the prosecution can tender it at a later time with another witness.
Yes, Your Honor. Now, Detective Markowitz, after hearing about this threat, what did you do?
Well, next, I obtained a court order for Mr. Becker's account records, specifically his call detail records.
And was a map made of these call detail records with the cell phone towers?
Yes.
Your Honor, permission to screen share Exhibit 15?
Certainly, go ahead.
Detective Markowitz, what is this?
This is a map with 3 different cell phone towers on it.
And are you familiar with this area?
Yes.
Are you familiar with the call detail records involved in this map?
Oh, absolutely.
Your Honor, the people move, and oh, sorry, is this a fair and accurate depiction of the map you reviewed in this case?
It is.
Your Honor, the people move to enter Exhibit 15.
Any objection?
Yes, Your Honor. First, I would object relevance. While I understand that relevance is a low bar, in this instance, the prosecution has not laid sufficient foundation to show that this exhibit is relevant to the trial, as there's been absolutely no foundation laid that Avery Becker had this phone on March 6, 2020. As an offer of proof, the defense will present evidence and multiple witnesses who will say that the phone had been lost, as I mentioned previously. This means that the phone was not in Ms. Becker's possession, which means that the location of the phone on these maps is not relevant today. Moreover, even if the court finds that this evidence is relevant, the probative value is so little that it is significantly outweighed by the risk of the jury presuming that the phone had some relevance to the crime, when in fact the defendant was not in possession of this phone. Further, that is all at this time, Your Honor.
Thank you, counsel. Ms. Seaman, could you have Detective Markowitz further identify or lay a foundation for this exhibit?
Yes, Your Honor. Detective Markowitz, what does this exhibit show?
Well, this exhibit shows the surrounding area of both Mr. Becker's house and Mr. Brackman's house, as well as 3 different cell phone towers, each with their varying gradations of range, as well as their antennas range, the 120-degree angle of their range. And I can then pinpoint Mr. Becker's CDRs based off of this map.
And could you tell where Miss Becker's phone was during this time?
I could, yes.
Your Honor, I again move to enter Exhibit 15 into evidence, if that is the sufficient foundation.
The foundation is sufficient. The exhibit will be admitted into evidence at this time and published to the jury.
Detective Markowitz, can you please locate Miss Becker and Mr. Brackman's home on this map?
Yes, Mr. Becker's house is here, and Mr. Brackman's house is here.
And based on the call detail records, could you determine a possible route that Miss Becker's phone took on this date?
Absolutely, I could. The following route that I found most likely that Mr. Becker took on March 6th of 2020 is as follows.
And how do you know this?
I know this because Mr. Becker's phone contacted 3 different cell phone tower antennas. From this, I could then pinpoint Mr. Becker's phone within the red. This is the location that each cell phone tower covers. I could then pinpoint his cell phone within those cell towers, and that is outlined in these various timestamps.
Now, Detective Markowitz, after reviewing all of the information in this case, what was your final opinion?
It is my final opinion that Mr. Becker went to Mackenzie Brackman's house on March 6th in 2020 and killed Mackenzie Brackman.
No further questions, Your Honor.
Thank you, counsel. Ms. Malloy, do you have any cross-examination for this witness?
Yes, Your Honor. Before I begin, may I have a moment to rearrange my virtual courtroom?
Certainly, go ahead.
Good evening, Detective Markowitz. I'd like to start off by talking to you about a couple of things you said on direct examination.
Absolutely.
On direct examination, you highlighted a route that you assume was taken by Avery Becker, isn't that correct?
Yes.
And you said that was the route taken, correct?
I said it was the most likely route that I believe in this case, based off of the call detail records that Mr. Becker took, yes.
So that's a yes to my question. You said that was the route that Avery Becker took.
That is the route that I believe Mr. Becker took, yes.
All right. Now I'd like to talk to you a little bit about your investigation. On direct, you talked about the videos, so let's look at those a little bit. Those videos have no timestamps?
No, they do not.
So you don't actually know what time the video that you admitted was taken, isn't that right?
No, I do not.
And you also never mentioned the time of Mr. Brackman's death?
No, but it is my opinion, based off of all the evidence at the scene, that Mr. Brackman was killed slightly before I arrived at the scene, and Ms. Becker that is what I believe. Slightly before I arrived at the scene, I do believe Mr. Brackman was killed.
Well, that's an important fact, and nowhere in your affidavit do you state that you believe that slightly before you arrived at the scene, Mr. Brackman was killed. Isn't that correct?
No, that is not correct. I actually do state that I do believe that leading up, I specifically state leading up to Mr. Brackman's death, I believe.
So you don't actually know the time that Mr. Brackman was killed, though?
No.
Kyle Kuzak's report mentions an interview with Taylor Perkins, isn't that right?
This is true, yes.
However, you never interviewed Avery Becker's father?
I felt there was no need to.
You never interviewed Avery Becker's mother?
No, I did not.
You never interviewed anyone on the mock trial team besides Alex Cifuentes, did you?
I did not. No.
You never interviewed Taylor Perkins, did you?
I did not. No.
You never interviewed the 911 caller?
There was no name given to me from the 911 caller. All of the evidence in this case pointed me to Mr. Becker.
Well, nevertheless, you didn't interview the 911 caller, did you?
No, I did not.
You never interviewed any neighbors that might have seen what happened?
No.
To be fair, you did interview Miss Alex Cifuentes.
I did, yes.
Now let's talk a little bit about the alternate suspect in today's case. You never investigated Blair Rollins, did you?
A Blair Rollins, no. And this was due to the fact that Mr. Becker's call detail records pinpointed him at the scene of the crime on March 6th in 2020.
Nevertheless, you didn't interview Blair Rollins, did you?
No, I never interviewed a supposed Blair Rollins.
In fact, nowhere in your affidavit do you even mention Blair Rollins, do you?
No, I do not mention Blair Rollins, no.
Now last, I'd like to talk a little bit about Avery Becker's alibi. You never gave Miss Becker the chance to prove she had an alibi, did you?
No, I did not. And this was due to the fact that the text messages that Mr. Alex Cifuentes sent me directly connected Mr. Becker to the call detail records that were placed on March 6th in 2020. The call detail records that were between a Mr. Taylor Perkins and a Mr. Avery Becker. These call detail records show direct timestamps.
Objection, Your Honor, non-responsive. I asked the witness a properly framed yes or no question, and the witness has gone far outside of the scope of the question that I asked.
Ms. Seaman, what's
Your
your
Honor,
response?
He asked a question, but it did not require, it did not have a yes or no answer. Detective Markowitz needed to be able to elaborate on this answer in order to explain what happened on this date.
May I respond briefly, Your Honor?
The objection is overruled. The witness may respond.
Yes, Your Honor. You never gave my client to prove that she had an alibi, yes or no?
No, as per my last answer, I felt that there was no need to.
And you never obtained Avery Becker's Celebrate data, or my apologies, you never obtained Avery Becker's call detail records for March 5th, 2020, did you?
March 5th, again, no. I felt that there was no need to.
You didn't do it, did you?
I did not.
And if you had obtained, would you agree with me that call detail records can track the movement of phones?
Absolutely, yes.
So you would be able to tell potentially whether or not Avery Becker's phone had been stolen if you had gotten the call detail records for March 5th. Isn't that right?
Yes, but I highly doubt that Mr. Becker's phone was stolen in this case.
So that's a yes to my question. You could have seen if it was stolen.
Yes.
And nevertheless,
No, I couldn't have seen it if it was stolen directly. No, I don't see how that actually would have shown me that Mr. Becker's phone was stolen. Phones don't track people, they track phones.
So you don't agree that it could have shown potentially out of the ordinary movements?
Could have done that, but I again don't see how that would directly show me whether or not Mr. Becker's phone was stolen on March 5th of 2020.
Well, I appreciate you don't see that. You didn't collect that data, did you?
No, I did not.
So we will never be able to know for sure, will we?
Objection.
For
Your
sure,
Honor.
no.
Asked and
Yes,
answered.
the objection?
This question has been asked and answered a few separate times in this case.
Any
May I
response?
respond? Yes, Your Honor. I have not asked the witness this specific question before. This is not asked and answered.
Go ahead and ask the question and let me determine whether it has been asked and answered.
Yes, Your Honor. Nevertheless, we will never, my apologies, Your Honor.
Go ahead.
We will never be able to know for sure, will we? And
That
this
was
is
asked
in
and
your-
answered. Proceed with your next question, counsel.
Yes, Your Honor. And you could have gotten a subpoena for Ms. Becker's call detail records for March 6, 2020, couldn't you? My apologies, Ms. Perkins.
I could have, but based on the 7 years that I've been a homicide detective, as well as the call detail records that I've observed in over 50 cases, I felt that there was no need to. I felt that there was a sufficient amount of evidence to point Mr. Becker to Mr. Brackman's murder.
While I appreciate that's your opinion, you didn't do it, did you?
No, I did not. I felt there was no need to.
I have no further questions at this time, Your Honor.
Thank you, counsel. Any redirect?
Yes, Your Honor.
Proceed.
Detective Markowitz, you were asked if you interviewed Miss Becker. Why did you not interview her?
Well, I was not able to interview Miss Becker because her attorney denied me that
Objection,
option
Your Honor.
to interview her.
And the
Your
objection
Honor,
is? Go ahead.
This testimony violates my client's constitutional right to remain silent. Furthermore, it is more prejudicial than probative, as there's virtually no probative value to this testimony at all. Miss Becker chose to remain silent based on the advice of co-counsel and I. And this would be vastly more prejudicial than probative, as it could lead the jury to believe that Miss Becker had some sort of ulterior motive for remaining silent besides just the advice of co-counsel.
Any response?
Yes, Your Honor. I would tend to agree, except opposing counsel on cross-examination brought this up and made it seem as though Detective Markowitz never even tried to examine Miss Becker in this case. And so therefore, this is proper redirect examination to show that he was unable to interview her, but made that effort, rather than what opposing counsel tried to suggest that he never made that effort.
May I respond briefly, Your Honor?
Counsel, you opened the door on cross-examination. I'll allow the witness to testify.
Yes, Your Honor.
Can you finish that statement, Detective Markowitz?
Yes, I contacted Ms. Becker to set up an interview. An interview was established. However, Mr. Becker's lawyer contacted me shortly after that interview would not be taking place and that all further communications would be between me and Mr. Becker's lawyer.
No further questions, Your Honor.
Thank you, counsel. Any cross?
No, Your Honor.
Thank you. This witness is excused. Thank you, Detective Markowitz. Can the prosecution call their next witness at this time?
Yes, Your Honor. The people call Alex Cifuentes.
Thank you, Ms. Nino.
May I proceed, Your Honor? Mr.
Yes,
Cifuentes,
you may.
please introduce yourself to the court.
Hi, my name is Alex Cifuentes. That's Sifuentes.
Do you currently go to high school?
Yes, I'm currently a senior at Colorado High School.
And do you know the defendant, Avery Becker?
Yes, I know Avery. We were friends and we were on the mock trial team together.
And did you know Mackenzie Brackman?
Yes, Coach B was our mock trial coach.
Now, based on your personal observations, what was the relationship like between Avery Becker and Coach Brackman?
It was horrible, to say the least. And it was like Batman and the Joker. Coach Brackman would always criticize Avery for one thing or another, and Avery never took that criticism well.
Now, I'm going to ask you a couple questions concerning the regional tournament last year. How did your team do at that tournament?
Oh, we did fantastic. We secured our spot at state, and Avery even won a couple of awards.
And did that seem to help the relationship between the two of them?
Not at all. If anything, it got worse. And Coach said some pretty nasty things to Avery. It was like, Houston, we have a problem. That's how bad they could get.
And how did Miss Becker react?
Avery became infuriated. I mean, it was like a shootout scene from Point Break where all heck breaks loose. Avery grabbed a Sharpie and stormed out of practice, all fast and furious. And on her way out, she wrote worst attorney.
Objection, Your Honor, may I be heard?
Yes, go ahead.
Your Honor, this witness is testifying to an incident in which Avery Becker vandalized Mr. Brackman's car. This is improper character evidence pursuant to Rule 404A and 404B. I anticipate that opposing counsel will use this testimony to say that Avery Becker had a character trait of anger and irrationality, and that she acted out of that anger when she didn't get her way. And I anticipate that they will use that to allege that she acted in accordance with that character trait when she allegedly murdered Mr. Brackman. Furthermore, this is improper character evidence pursuant to Rule 404B, as I anticipate that they will use this prior bad act to show that Ms. Becker acted in accordance when she allegedly broke into Mr. Brackman's house to vandalize it. Both of these are inadmissible pursuant to Rule 404. Furthermore, this is substantially more prejudicial than probative, as it would lead the jury to believe that Avery Becker acts irrationally and angrily when she doesn't get her way, which substantially outweighs any probative value of this testimony.
Thank you, counsel. Any response?
Yes, Your Honor. Under Rule 404A1, evidence of a person's character or character trait is only inadmissible if it is being used to prove that on a particular occasion, the person acted in accordance with the character or trait. Here, we are not using this testimony to demonstrate a character trait of the defendant, but rather the people offer this evidence as a sequence of events, because Mr. Cifuentes will testify that as a result of vandalizing Coach Brackman's car, the defendant was kicked off the mock trial team. This then gave the defendant the motive and intent to break into Coach Brackman's house and trash it to get back at him. Pursuing to Rule 404B2, evidence of a crime wrong or other act is inadmissible or is admissible to prove motive or intent. The prosecution is using this testimony to show the action that led to Ms. Becker being kicked off the mock trial team. Ms. Becker being kicked off the mock trial team is what gave her a motive to break into Coach Brackman's house. In addition to that, Rule 404B2 also states that evidence of a crime, wrong, or other act is admissible to prove a lack of accident. Ms. Becker claims that the permanent vandalization of Coach Brackman's car was an accident, and this testimony will prove that it was not. In regards to the more prejudicial than probative objection, any evidence in court today will have some sort of prejudicial effect. However, this testimony's probative value substantially outweighs the prejudicial effect.
Thank you, Ms. Dino. Any reply?
Yes, Your Honor, may I have one moment?
Very brief.
Your Honor, if
And please
opposing
make your
counsel,
reply brief as well.
yes, Your Honor. Your
Thank
Honor,
you.
if opposing counsel is not going to use this to show that Ms. Becker acted in accordance with a character trait, then I withdraw that objection. However, I'm objecting to the actual vandalism of the car and not the subsequent actions taken by Mr. Brackman after that vandalism. The subsequent actions taken later were what the prosecution claims is motive. I am not objecting to those actions. I'm objecting to the vandalism of the car, as I anticipate that they will use it to show that Ms. Becker acted in accordance when she allegedly broke in to vandalize Mr. Brackman's house. Furthermore, they cannot use this testimony to prove that there was a lack of accident, because this witness was not there when Ms. Becker vandalized the car, and he does not know what she was thinking as she vandalized the car. He cannot prove that she believed that she knew what she was doing, and therefore cannot prove that it was lack of accident. This is substantially more prejudicial than probative to allow the witness to testify that it wasn't an accident, as he was not there.
Thank you, counsel. I am going to overrule that objection. The witness may proceed to the description of the facts and any relationship to those facts. Go ahead.
Mr. Cifuentes, could you just repeat what Ms. Becker did after Coach Brackman made such remarks?
Hey, Avery took a Sharpie from where we were practicing and stormed out of the room all fast and furious. And she wrote Worst Attorney Award all over Coach's vintage Porsche 911.
Do you know if Mr. Becker had a consequence to this action?
Oh, yeah. Avery was kicked off the team.
And after this incident, did you hear from the defendant?
Yes, Avery texted me and asked if I would talk to Coach on her behalf.
And did you?
Yes.
And what happened when you talked?
Well, Avery, I told her that Coach wasn't going to back down. And Avery said that she was going to break in and trash Coach's house.
Did you?
Objection, Your Honor. May I be heard?
Very briefly.
Yes, Your Honor. I re-raise my co-counsel's objection to the content of the text messages, specifically Avery's statements about what she would do to Mr. Brackman's house. These are hearsay and cannot fall under Rule 801D2, as not enough foundation has been laid to show that those indeed were Avery Becker's texts. Furthermore, this is substantially more prejudicial than probative, as once again, the foundation has not been laid to show that they are Avery Becker's texts, and allowing this witness to testify that those were Avery Becker's words is substantially more prejudicial than probative.
The objection is overruled. Go ahead and proceed, counsel.
So, Mr. Cifuentes, when Mr. Becker said that she was going to vandalize Coach Brackman's house, what did you respond to that?
Oh, I was all dazed and confused, so I asked what she meant by that.
And what did she say?
She said that she was going to wait until Coach was at work, and break in and trash the place.
And after Coach Brackman was murdered, did you hear from the police?
Yes, I was reached out and talked to Detective Markowitz on the phone, and after that, he asked me to come in for a full interview. So I went down to the station.
And did you tell him what happened?
Yes, I told him everything.
Now, you said that Avery Becker had a really tense relationship with Coach. Correct?
Yes.
Objection, Your Honor. May I be heard?
Yes.
This is a leading question pursuant to Rule 611. This is improper for direct examination.
That objection is sustained. Proceed, counsel. Re-ask the question in a proper format.
Your Honor, may I just move on?
Yes.
So let's talk about the Fry Shack on Thursday, March 5th. Were you there that day?
Oh, yeah. There's no place like the Frat Shack.
And who did you see there?
Avery and Taylor were both there, and so were the usual suspects, the whole mock trial team.
Did you see if Mr. Becker had his phone?
Oh, yeah, Avery had her phone. Avery let me play a new game on it.
And did you end up taking the defendant's phone?
No, I have my own phone.
So switching gears, let's talk about a person named Blair Rollins. Do you know him?
I know sort of Blair. I've said hi to him in the hall every once in a while, but that's about it.
And did you give the defendant's phone to Blair Rollins?
No, that's completely absurd.
Now, finally, you said that Mr. Becker was a lawyer on the mock trial team. Was he also a witness?
Oh, yeah. Avery could sell you anything on the stand.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any cross-examination of this witness?
Yes, Your Honor, but first, may I have a moment to rearrange my virtual courtroom?
Yes.
Before I begin, can Your Honor hear and see me all right?
Yes.
Oh. You have stated that you and Avery are friends, correct?
Yeah, we were friends before she killed Coach Brackman.
However, there was also a rumor that you and Avery were rivals, wasn't there?
I wouldn't say rivals. We were on the same mock trial team.
But there was a rumor, yes or no?
Rumor would be stretching it. You can't really have a rivalry with someone on your team.
You created an affidavit for today's case?
Yes.
You swore to tell the truth?
Yes, I did.
And you knew you had the obligation to update that affidavit with any relevant information prior to today's trial?
Yes, I did.
Your Honor, at this time, may my trial technician have permission to display the witness's affidavit for purposes of impeachment?
Proceed, Ms. Carrington.
Now, let's scroll through the affidavit so the witness can identify it. That's your signature at the bottom, correct?
Yep, that's Alex Cifuentes.
So this is your affidavit?
Yes, it is.
Now, if we could go to line 110. Please follow along silently as I read aloud. Last, I want to address the rumor that Avery and I were somehow rivals. Did I read that correctly?
Yes, and I say I wholeheartedly
Objection, Your Honor. May I be heard?
Certainly. Go ahead.
I object non-responsive. I asked a properly framed yes or no question. The question was, did I read that correctly? This question requires no response other than yes or no. And if the witness wants to explain this answer further, they may do so on redirect on his own time. As this is a time competition, I ask the court to direct the witness to answer as briefly as possible.
The witness is directed to answer the question.
So that's a yes to my question. I read that correctly.
Yes, you did read that correctly.
Thank you. The witness's affidavit is no longer needed. Oh, I'd like to talk to you a little bit about Blair Rollins, the alternate suspect. You went to school with Blair, didn't you?
Yes, Blair also went to Colorado High School.
And you were friends with Blair, weren't you?
No, I mean, I'm just kind of a friendly guy and I would say hi to people, but that doesn't really make me friends with Blair.
Exactly. You said hello and goodbye to each other in the hallways.
Yep.
And you are aware that both Avery Becker and Taylor Perkins will testify that you and Blair were friends, aren't you?
No, I'm not. I'm not friends with Blair and I haven't heard Avery or Taylor say otherwise.
And you knew that Mr. Brackman had defended Blair's father on a murder charge?
No, I didn't. No, I didn't.
Well, you knew that Mr. Brackman had defended a student's father, didn't you?
Oh yeah, I mean, Coach Brackman was always doing that kind of stuff. He wanted to help out students.
And we just talked about the alternate suspect, and in a moment we're going to talk about the prosecution's awful investigation, but let's talk about Avery's alibi. Taylor Perkins was also on the mock trial team with you and Avery, correct?
Yes, before she stepped down so Avery can make it back on for regionals.
Avery and Taylor were best friends, weren't they?
No. I like to think me and Avery were friends too, but yeah, Taylor Perkins was also one of Avery's friends.
Your Honor, I just want to clarify, are you still here?
Yes, I am.
Thank you. Like you said on direct, you were at the Fry Shack the night of March 5th, 2020, correct?
Oh yeah, us mockers like to go there.
And Taylor and Avery were there together, weren't they?
Yes, they were.
You were playing on Avery's phone?
Yeah, I got to play a new game on it.
And Avery's accusing you of stealing that phone, correct?
Oh, I never stole Avery's phone if that's what they're trying to insinuate.
I'm not trying to insinuate anything. I'm asking you if you know that Avery is accusing you of stealing that phone.
I didn't know that Avery was accusing me. I had heard about it, but it's just absurd. Why would I steal someone's phone?
So is that a yes or a no to my question? Avery is accusing you of stealing your phone, stealing her phone.
Yes, that's a yes. Sorry, that was confusing.
Oh, let's talk a little bit about the awful investigation of the prosecution. You are aware of our concerns that you faked the text messages in Exhibit 14, aren't you?
I was just made aware of them during this trial, not prior.
And you never provided your phone to the police?
I offered to bring it in, but they just told me that I could send screenshots instead.
So Detective Markowitz never saw your phone, did he?
Oh, he saw this exact text.
He never saw your phone, yes or no?
No, he didn't ever tangibly hold my phone, no.
And he never downloaded any information using Cellbrite?
I'm not really sure what Cellubrite is, so I don't know.
So to your knowledge, nothing was ever downloaded from your phone?
Not to my knowledge, no.
Thank you, Your Honor. At this time, I have no further questions.
Thank you, Ms. Carrington. Ms. Dino, do you have any redirect?
Briefly, Your Honor. On
Proceed.
cross-examination, when you were asked about your witness statement, did you ever disagree that there was a rumor between you and Mr. Becker?
No, I understood it's like if I brought that rumor, but I had heard about it and I wholeheartedly disagreed with it from the start.
But you never disagreed with the fact that there was a rumor in the first place?
No.
Thank you, Your Honor. No further questions.
Thank you, counsel. The witness is excused at this time.
Thank you, Your Honor.
Mr. Deniza,
Yes, Your Honor. At this time, the people.
you want to call your next witness?
Yes, Your Honor. The people call Mr. Kyle Kuzak to the stand.
Mr. Kuzak? Are you here?
Yes, Your Honor.
There you go. Thank you. I just wanted to see a picture. Thank you. Mr. Deniza, you may proceed. Or I apologize. I keep mispronouncing that name. It's Mr. Deneza. Is that correct?
Yes, Your Honor. Thank you.
Proceed.
Could you please introduce yourself to the jury?
Hi, my name is Kyle Kuzak, Kuzak.
What do you do for a living, Mr. Kuzak?
Well, currently I am a crime scene reconstructionist for the Denver Police Department.
Crime scene reconstructionist. Could you explain to the jury what that means?
Well, crime scene reconstruction is the assembly of the facts at the crime scene in order to make a clearer picture. Now, you heard the Detective Markowitz, say that he took photos and was at the crime scene. Detective Markowitz gives me the pieces so that I can assemble this very difficult puzzle. Now, what makes me your puzzle master is that we don't have the back of that puzzle box to see what's really going on or what actually happened. What makes me the master is I have to put those pieces together myself.
Do you have any certification in this field?
Yes. So when I first started practicing 19 years ago, I was board certified by the Colorado Bureau of Investigation.
And during your 19 years, what sorts of cases have you worked on?
Well, in CSR, I specialize on complex crime scenes. So that can be anything from armed robberies, burglaries, break-ins, homicides, you name it.
Did the people ask you to reach any expert opinions for today's case?
Yes.
Did you reach any?
I did, yes.
Your Honor, at this time, I offer Mr. Kyle Kuzak as an expert in the field of crime scene investigation and reconstruction.
Thank you, counsel. Any objections?
No objections, Your Honor.
You may proceed.
Mr. Kuzak, you
The witness is accepted as an expert.
My apologies, Your Honor.
Go ahead.
Mr. Kuzak, you mentioned some expert opinions. What were they?
Well, first, the defendant tried to get into Mr. Brackman's house through the front door. And when she couldn't get in, she moved around to the back side of the house where she gained access. From the time that she entered the house to the time she left, Mr. Brackman died.
Now, let's talk about how you reached these opinions. How did you first become involved in today's case?
Well, as I usually get involved with these CSR cases, I got a phone call from the Detective Markowitz, saying, we've got a messy crime scene on our hands. I got a lot of puzzle pieces. I need your help.
Now, once on the scene, how do you go about conducting your investigation?
Well, generally, I leave the photo taking to the forensic team. I took a couple of photos, Exhibit 18 is one of them, but more, I try and get a bird's eye view, a macro level, if you will, of the crime scene.
You have a certain methodology that you use when conducting such an investigation?
Yes, I implement a 5-step crime scene reconstruction process.
Could you briefly explain this for the jury?
Sure. So going back to my puzzle analogy, step 1 is my recognition and my documentation. It's kind of like going to the store and looking at the different puzzles. Now, steps 2 and 3 are my collection and my evaluation of the evidence. So I dump the puzzle out on the table, I sift through the pieces, and I start to put them together, looking for evidentiary relationships. Step 4 is when I really try those difficult pieces, perhaps the sky's the same color, and I'm trying to fit them together and see how the picture really looks when the puzzle is assembled. This involves hypothesis testing and peer review. And step 5 is my ultimate crime scene reconstruction, where I put everything together.
Now, let's walk through what occurred on the day of March 6th in light of this method. How did the perpetrator enter Mr. Brackman's home?
Well, as I said earlier, and from the Ring doorbell videos, the perpetrator, the defendant, first tried the front door, couldn't get in, so she moved around to the back side of the residence, where she entered through a glass sliding door.
Now, once inside, what happened?
Well, as the intruder was moving around to the back side of the house, the victim, Mr. Brackman, was receiving doorbell notifications on his phone. And maybe he thought first that it was a package arriving at his front door, but when he heard the turn of the front door and when he saw the cameras from the backside of his residence, something much worse was going on. So he ran to the kitchen and grabbed a knife to arm himself. And to answer your question, the two met each other just inside the back door.
Once the perpetrator met Mr. Brackman, what happened?
Well, Mr. Brackman presented force to the intruder, and the intruder responded with force. There was some sort of fight the detective referred to it as a scuffle, some altercation just inside the door that moved to a table and turned deadly.
Now, what evidence points to this scuffle, as you say?
Well, there's black marks on the floor just inside the door. In CSR, we call them scuff marks. There's a broken plate and a knocked over chair.
Now, as this scuffle ensued, how was Coach Brackman killed?
Well, the defendant gained control of the knife from Mr. Brackman. She got control of it. And while they were in this close scuffle, she reached around and she stabbed him in the back.
Now, how exactly was Mackenzie Brackman stabbed?
Well, if you want me to get all scientific on you, well, first, he was stabbed kind of in the lower back. But if you want me to get scientific with you, he was stabbed just inferior to the scapula. The knife actually nicked the inferior portion of his scapula, glanced his pulmonary artery, and right in the middle of his aorta, the largest artery in the body. Now, when the knife was first inserted, it acted somewhat as a plug. Maybe Mr. Brackman would have died if the knife stayed in. But the real damage was done when the knife was removed. He died shortly after that.
Now, having gone through all of the evidence, what can you conclude about the murder of Mackenzie Brackman?
Well, it was obviously a burglary gone wrong. The perpetrator entered the residence, was met with force, and then responded with it and killed Mr. Brackman.
Now, let's move on to the defense's expert witness, Professor Blake Van Owen. Do you know Professor Van Owen?
Oh boy, I do know, to answer your question, Professor Van Owen.
And how do you know her?
Well, I've seen her on Zoom at a couple of meetings. She pretends to act all smart, but she doesn't know much.
What do you mean?
Well, going back to my puzzle analogy, you know how I told you at the beginning that the thing that makes CSR so hard is we don't have the picture of the puzzle on the back of the box. To me, it seems like she tries to find a picture online or come up with a different picture and then jam the puzzle pieces together in order to prove her theory. Now, as you know, it just doesn't work.
Now, in light of her theory specifically, why doesn't it work?
Well, she's got a great picture this time and it sure doesn't match up. So she wants you to believe that Mr. Brackman was just sitting at his counter, just doing his thing, and somebody broke into his house, opened the door, you heard the noise in Exhibit 12, walked across the wood floor, went up behind him, and stabbed him in the back. She can't explain the scuff marks on the floor, the broken plate, or the knocked over chair, or the Ring doorbell notifications.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any cross-examination of this witness?
Yes, Your Honor, but before I begin, may I have a brief moment to rearrange my virtual courtroom?
But very briefly, and please leave the camera on. You may proceed. You are on
Before I
mute.
begin,
Okay.
Before I begin, Your Honor, may I inquire as to how much time I have remaining?
Certainly. How much time is remaining?
The defense trial technician put it on the chat, Your Honor.
Okay.
Mr. Cook, I'd like to talk about a few things you stated during direct examination.
Sure.
You stated that Mr. Brackman thought that initially the movement at the front door might have been packaged because of the Ring doorbell system.
No, ma'am. I'm not saying that movement at the front door might have been a package. I'm saying that initially maybe he didn't think it was an intruder, but once he got multiple doorbell notifications on his phone, he knew he was getting robbed.
But Mr. Cusack, just to be clear, nowhere in your affidavit do you state that Mr. Brackman received several notifications that alarmed him of the intruder?
I'm sorry, I don't think you're understanding my testimony. So my testimony is that once he received these notifications, remember, there's a lot of cameras, and how this system works is these cameras placed around the house, every time they're activated, they send a notification. So what I gathered from Mr. Brackman receiving notifications from these different systems is as the perpetrator moved around, he continued to receive notifications.
Exactly, Mr. Kuzak. And my question was, nowhere in your affidavit do you include that Mr. Brackman received several of these notifications. You only include that there was a Ring doorbell security system.
I include that he was alerted of the Ring doorbell security system. So I think we're speaking the same language here, counsel.
Okay, Mr. Kuzak. And just to be clear, nowhere in your affidavit do you state that you analyzed the Ring doorbell security system cameras?
I personally, no ma'am, did not. I work more with the puzzle pieces, putting them together instead of actually attaining the pieces.
Exactly, but you would agree with me that the Ring doorbell security systems are part of the puzzle pieces because you analyzed them, correct?
Oh, they absolutely are. No, ma'am, I didn't analyze the Ring doorbell. You just asked me that. I didn't analyze that.
Okay. And now part of your conclusion was that the perpetrator at the door matches the general height and build of Avery Becker, correct?
Yes.
However, nowhere in your affidavit do you specifically state Avery Becker's height?
Well, when I said general height and build, I wasn't trying to use my silver bullet. It was merely a tiny corner piece of the general puzzle. So I don't think it was that important. And to answer your question, no.
So just to be clear, your testimony today is that you don't think Avery Becker's height was important.
I think it was one of the many pieces. I don't think it was the one piece that I used, or I know that it wasn't the one piece that I used to place Avery Becker at the scene of the crime.
Mr. Becker, yes or no, you don't know the victim's height either?
It's Mr. Kuzak and no.
Excuse me, Mr. Kuzak, you don't know the victim's height?
I do not. No, ma'am.
In fact, you never measured the body on scene?
No, I leave that to the forensic people. I'm more worried about what happened before the victim died.
You say you leave it to the forensic people. You used Exhibit 19, the autopsy report, as part of your review for this investigation?
Yes, ma'am.
And nowhere in that report is the victim's height included, correct?
No, but I'm struggling to understand why that's important.
Mr. Kuzak, you concluded that the way the perpetrator disarmed Mr. Brackman is with a bear hug, correct?
No, I'm saying that the way the defendant, your client, killed Mr. Brackman was with a bear hug.
Your Honor,
Exactly.
may I interrupt briefly? I believe our timekeeper has been kicked out of the meeting.
Okay. The monitor, can you check the waiting room and make sure that the timekeeper is logged back in? I am not here. I'm not hearing a response from the monitor.
It appears our timekeeper has been missing for the entirety of this cross-examination.
Well, can you please show yourself the court monitor so that I can, it's hard to discuss this.
Your Honor, at this time, Rule 2.2.2 states that time must be stopped as there is a technical difficulty.
Time will be stopped, absolutely.
Your Honor, last time that I saw on the chat was 5 minutes remaining.
That's correct.
Thank you.
So to our, who is our courtroom monitor? I apologize, I'm not seeing a name. And you are on mute, so I cannot hear you.
Your Honor, I don't know if she is present. She did put her phone number in the chat if
Okay.
someone would like to courtroom monitor. I believe it's further up at 4:19 p.m. and I can read the phone number. I do not have a phone on me to call her, but if someone else would like to.
Yes, somebody from the D team, could you please contact both your court or your timekeeper to find out why she's not in the Zoom meeting? Do you know that?
It appears to be technical difficulties, Your Honor. However, I'm also not currently in possession of a cell phone.
Okay. That makes this difficult. So,
Your Honor, if I may, for
yes,
the
go ahead.
if it's acceptable to the opposing counsel, our timekeeper would be perfectly able to keep time for them until this technical difficulty is sorted through.
Let me contact our courtroom monitor, though.
Of course, Your Honor.
Your Honor, as opposing counsel has brought up, Rule 2.2.2.3, I believe, states that rules of competition allow for, if one timekeeper is missing, to defer to the other timekeeper.
And I understand
Your
that,
Honor,
but this is
Your Honor, the
a
remaining
team member, so I'm going to make sure that the monitor knows what's going on.
Yes, thank you.
Courtroom monitor is,
Your Honor, the remaining
This is-
time is 4:25.
I understand. Thank you, Mr. Alexander. Please confirm that the team member from the defense, their timekeeper is missing. Let us know whether she will be let into the meeting. Period. Okay, so I just texted our courtroom monitor. Hopefully we will find out what happened with the timekeeper. In this matter, I will go ahead and set the clock at, I'd like you to set the clock at 5 minutes just to make sure that there is no difficulty here, and you may proceed. Ms. Melendez?
Yes,
Go
Your Honor.
ahead.
Mr. Cusack, it is your conclusion that the perpetrator stabbed Mr. Brackman in a bear hug fashion, correct?
Yes.
And wouldn't you agree with me that if the perpetrator were shorter than the victim, it would be harder to reach around and stab in a bear hug?
No, not quite. So I believe how you positioned your hand was incorrect. You positioned your hand in kind of a downward fashion. We don't know for sure, but it's just as easy for the perpetrator to reach around and stab in an upward manner.
But just like you mentioned, we don't know for sure.
No, the nature of crime scene reconstruction is speculative. We know nothing for sure.
And just to be clear, earlier you stated that you didn't know the victim's height or Miss Becker's height specifically.
Question asked and answered.
Any
Your Honor,
response?
yes, Your Honor. This question is asked in a different context as I am clarifying the earlier testimony just to make sure that I am understanding Mr. Cusack correctly and that I am understanding whether or not he deems the victim's height and Miss Becker's height important to his investigation.
Counsel, do you have a response?
Yes, Your Honor. Although counsel said this is for a different purpose, I believe this question has been asked and answered and serves the same purpose. Again, asking about the height and weight, the specifications versus Mr. Cusack, who offered a generalization of this statement.
Thank you, counsel. The witness may proceed with his, or the question may proceed. Go ahead, counsel, and the objection is overruled.
So Mr. Cusack, just to be clear, earlier you stated you didn't know Miss Becker's specific height or Mr. Brackman's specific height, yes or no?
That's right.
And I want to talk about some more of your conclusions. You stated you agree with Professor Van Owen on the fact that the knife came from the same knife block that was found in the kitchen, correct?
No, as I reviewed Professor Van Owen's case, good old Van Owen, she tried to say that the knife came from off the premises. That is absolutely wrong. No, Mr.
But
Brackman,
Mr. Kuzak, that wasn't my question. You agree that the knife came from the knife block, according to you?
I'm not quite following you. What I believe to happen is that Mr. Brackman grabbed a knife from the knife block to arm himself. That's all I know. I'm a little confused by your question.
Exactly, Mr. Kuzak. Therefore, you agree with Professor Van Owen that that knife taken from the knife block is a different brand from the rest of the knives in the knife block. Yes or no?
I think it's a fact. I don't know if we're agreeing. I don't think I've ever agreed with Professor Van Owen, but the one thing that we can agree on is
Mr.
that the knife-
Mr. Kuzak, yes or no, is the knife a different brand from all of the knives in the knife block?
Well, that's a different question, and yes.
Now, you encountered a series of cast-off and blood droplets, correct?
Yes, ma'am.
However, those pictures became lost and corrupted.
They did. It didn't harm my investigation or hinder it in any way.
However, those exhibits are not in trial today, correct?
No, they are not.
Now, I want to talk about the alternate suspect in today's case. You were aware that Blair Rollins is an alternate suspect?
No, not an alternate suspect.
You prepared a CSR witness tracking sheet, correct?
I did, yes.
And Your Honor, at this time, I ask that the defense trial technician display Exhibit 17.
Yes, go ahead. Display the exhibit.
And defense trial technician, can you scroll down a page to the entirety of the exhibit, please? Can you scroll back to the top? Mr. Kuzak, this is the CSR witness tracking sheet, the flow chart and evidence tracking sheet that you prepared for today's case?
Absolutely.
Your Honor, at this time, I move to admit Exhibit 17 into evidence.
Any objection to this exhibit?
Yes, Your Honor. I object on the grounds of hearsay as well as cumulative. Hearsay is an out-of-court statement being used for the truth of the matter asserted, and cumulative as under Rule 703, an expert witness can testify as to certain evidence that normally would be inadmissible in the court of law due to circumstances such as hearsay, as in this case. Thus, this witness would be perfectly capable of testifying to the contents of the exhibit at hand. Therefore, it is cumulative evidence for the jury and unnecessary.
Your Honor, may I respond?
Ms. Melendez, yes, go ahead and respond.
Your Honor, I agree with opposing counsel on the grounds of Rule 703. However, the reason that I am admitting this exhibit is for purposes of impeachment, as I just asked Mr. Kuzak whether or not he was aware that Blair Rollins is an alternate suspect in today's case. He denied that fact. Therefore, Exhibit 17, the exhibit that he prepared for today's trial, goes directly to prove or disprove whether or not he was aware of this fact. And it goes to the bias and credibility of the witness. And all of this is fair ground under Rule 613, as extrinsic evidence may be admitted under Rule 613 for purposes of impeachment.
Any reply, counsel?
Your Honor, I would still argue that the witness is able to testify as to the contents without the evidence being directly admitted. Therefore, I would ask that you see this as cumulative evidence, as it truly is.
The exhibit will be admitted into evidence for purposes of impeachment.
Now, Mr. Kuzak, I have Exhibit 17 in hand, and if defense trial technician could follow along with my instructions. In the last box, top right, where it says summary of information and evidence, all the way to the bottom, it reads familiar with S1D, comma, S2, and S3, unlocated party, Blair Rollins. Did I read that correctly?
Yes, ma'am, you did. If you'd allow me to explain.
Mr. Kuzak, yes or no, Blair Rollins is mentioned as an alternate suspect in this exhibit?
Counsel, you're taking my words out of context. You asked if there's an ulterior suspect today. There's not. Back when I did this interview.
Mr. Kuzak, objection, Your Honor.
Yes.
Objection, Your Honor, non-responsive. I properly framed a yes or no question. I asked whether or not I read the information correctly, and Mr. Kuzak is going far beyond the scope of that question. This is a timed competition. If Mr. Kuzak feels the need to explain himself, he may do so on redirect.
The witness will answer the question.
So, Mr. Kuzak, I read correctly that Blair Rollins is an unlocated party and that she is a suspect identified as S3 on the exhibit you prepared, yes or no?
You do read that, but you're taking the time out of context.
Thank you, Your Honor. I have no further questions at this time.
Thank you, counsel. Any redirect?
Yes, Your Honor. May I ask for a brief time check?
Certainly. Could the timekeeper tell us what the remaining time is?
You have 42 seconds remaining.
Thank you.
Thank you.
Mr. Cusack, I have one question for you. Is Blair Rollins a suspect today?
No, and this is what I was trying to get out before the other side cut me off. So Blair Rollins, initially, when we gather pieces of the puzzle, we have tons of suspects. In fact, we had 3 suspects in this case. Now, that was over the summer, and now we're in the spring. We're down to 1 suspect, and it's the defendant, Avery Becker.
Thank you. No further questions, Your Honor. At this time, the people rest.
Thank you, counsel. Is the defense ready to put on their case in chief?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
Thank you.
And Your Honor, before I begin, I have 2 requests for the court at this time. First, Professor Van Owen, as she has come to testify, has prepared an exhibit for today's case, and that would be Exhibit 21. And although Professor Van Owen would like to use the real-life knife to explain her concerns with the prosecution's theory, we are limited to only exhibits and demonstrative purposes. So at this time, I am asking for permission pursuant to Rule 4.7 of procedure, that we may be allowed to make edits to this exhibit throughout the testimony. And just to be clear, we still plan on laying foundation and identifying this exhibit throughout the course of Professor Van Owen's testimony. We simply need permission to actually make those changes during testimony, Your Honor.
You may proceed and make any changes that are necessary during testimony.
And Your Honor, my second request before I begin is that pursuant to Stipulation 4, both the prosecution and defense have agreed that the Exhibit 22 is a recording of Jonathan Rollins threatening harm on Mr. Brackman. Therefore, at this time, and because both parties agree on the validity and contents of this exhibit, the defense moves to admit this exhibit into evidence.
Any objection, counsel?
Your Honor, I would ask that the opposing counsel admit this during the direct of Professor Blake Van Owen, as Professor Van Owen has knowledge to testify in this field and would be perfectly capable of doing so.
Your Honor, may I respond?
Yes.
As stated in Stipulation 4, directly, both prosecution and defense already agreed to contents and validity of this exhibit. Therefore, Professor Van Owen does not need to testify to this in order to be admitted, and this is stipulated as number 4, Your Honor.
If I may, Your Honor.
The exhibit will be admitted into evidence. Proceed, Ms. Melendez.
Thank you, Your Honor. Please introduce yourself to the jury.
Good evening. I'm Professor Blake Van Owen. I'm also a private investigator.
Professor Van Owen, how are you involved in today's case?
I'm here to discuss the investigation into the death of Mackenzie Brackman, specifically Avery Becker, the defendant's alibi, the alternate suspect, and the awful investigation that led to overlooking those 2 crucial aspects of today's case.
Can you tell the jury a little bit about your qualifications to conduct an investigation of this nature?
Of course. I earned my master's degree in criminal justice from Ashford University. I actually started my career as a police officer with the Aurora Police Department. Since then, I've worked as a private investigator, and for 5 years now, I've lectured on police practices and social justice at the University of Colorado, Denver.
Have you ever testified as an expert before?
I have. I've testified as an expert in the U.S. District Courts of Colorado, Kansas, and Arizona, and the U.S. State Courts of Colorado, Nebraska, New Mexico, and Wyoming.
What areas of expertise have you been qualified under?
I've been qualified under many areas of expertise, but the ones that pertain most closely to today's case are crime scene reconstruction, cell tower analysis, police investigation tactics, and forensic evidence techniques.
Your Honor, at this time, I ask that the court recognize Professor Blake Van Owen as an expert in general police procedures, and with an emphasis in cell tower analysis, crime scene reconstruction, and forensic evidence.
Any objection, Mr. Dineza?
Yes, Your Honor. People request a brief voir dire.
Certainly. Proceed.
You claim to be an expert in police practices, correct?
That's correct.
But you were only a part of the police force for 9 months. Isn't that right?
Yes, I also have a master's degree in criminal justice.
And that 9-month experience was over 15 years ago, correct?
That's correct.
So your only experience working in the police force was a 9-month-long experience over 15 years ago.
I'm also a private investigator, and I do have a master's degree in criminal justice.
I didn't ask about your private investigation job. I asked if your experience working as a police officer was from over 15 years ago and was only a 9-month-long experience.
Working as a police officer specifically was, yes, only 9 months long.
Your Honor, I have no objection to the witness being entered into the fields, specifically in regards to cell tower analysis, as well as I apologize, but I believe the other requested was in regards to CSR. However, as their only experience in regards to police practices was a 9-month-long experience from over 15 years ago, I do object to their expertise in this regard. Now, notwithstanding the technical requirements of Rule 703, expert testimony must rise to a threshold level of both relevance and reliability. Now, with that being said, this court, as the gatekeeper, should exclude testimony in regards to Professor Van Owen's expertise in police practices, in general police practices, because Professor Van Owen's experience in this regard is far too attenuated.
The witness is going to be accepted as an expert in the fields as requested by defense counsel. Counsel, please proceed.
Yes, Your Honor. Professor Van Owen, you talked a little bit about the awful investigation, alibi, and alternate suspect. We're going to talk about all of those. But let's first start with the awful investigation. Can you tell us what you meant by this?
Of course. Many aspects of the prosecution's investigation were rushed or designed to only consider evidence that fit their biased perspective. Now, for example, we have the way the victim died, the murder weapon or the knife itself, and the various technology involved in today's case, including the call detail records and the Ring doorbell system.
Let's start with the conclusions about how the victim died. Tell us more about those.
Well, the prosecution asserts that the victim initially possessed the knife and it was wrestled away from him by the intruder, who then used it to stab him in the back. Now, this rests on a few large assumptions. Assumptions about the scuff marks found by the back door, assumptions about the broken plate, assumptions about the supposedly overturned chair, and assumptions about the murder weapon or the knife itself.
Please elaborate on these assumptions.
I'll start with the scuff marks. The scuff marks can't be carbon dated, so they could have come from the crime, as the prosecution promptly assumed, but they also could have come from a week before, a year before, or possibly even before Mr. Brackman even owned the residence. As for the broken plate and supposedly overturned chair, these are consistent with a number of different plausible scenarios.
So based on that, do you have any other concerns with the evidence found at the crime scene?
I do, actually. Regarding the knife that was found near the victim, it is unlike any of the other knives found in the Brackman residence. This suggests that it was, instead of being taken from the residence, as the prosecution suggests, It was taken from outside the residence, suggesting a intentional homicide. In addition, the style of the knife and the wound it caused are not consistent with the prosecution's theory. I even prepared an exhibit to help explain this, and I cut out the one that, as you asked me to, for demonstrative purposes.
Now, Your Honor, permission for defense trial technician to display Exhibit 21 on the screen.
You may proceed.
And Your Honor, at this time, may the record reflect that the demonstrative cutout version of Exhibit 21 up on the screen for the rest of trial will be referred to as 21D, as in demonstrative.
Certainly.
Now, Professor, I'd like for you to direct your attention to 21 on the screen and 21D in front of you. Do you recognize these exhibits?
Yes, this is the exhibit I prepared to help show how a knife of this nature could be held.
Would having Exhibit 21 and 21D helpful for the jury to understand your testimony?
Yes, because these two knives, this one and the knife that was actually used in the crime, are so similar, it would help me explain how the knife could be gripped.
Your Honor, at this time, I move to admit Exhibit 21 and 21D into evidence and subsequently publish both to the jury.
I need to be able to see 21D before it can be published to the jury.
Yes, Your Honor. Professor Van Owen, if you could please hold up the cutout version of 21D.
Thank you, counsel. They will both be, actually, counsel, Mr. Daneza, do you have any objections to these two exhibits being published to the jury?
Yes, Your Honor. I object on the grounds of hearsay as well as cumulative. The knife and the way it's being held, specifically the way the knife is being held, is an out-of-court statement being used for the truth of the matter asserted. Professor Van Owen is claiming this is exactly how the knife was held. Therefore, it is hearsay. Cumulative evidence, Professor Van Owen is able to testify without this evidence under Rule 703, and therefore it is cumulative and unnecessary for the jury to see.
Your Honor, may I respond?
Yes, Ms. Melendez, proceed.
Your Honor, yes, Your Honor. As to cumulative pursuant to Rule 403, this is not cumulative as Exhibit 21 is simply a picture of how a knife could be gripped, and therefore the cutout version would help aid and help the jury understand how the gripping of the knife actually plays into the prosecution's theory and defense theory and the concerns that Professor Van Owen has with the prosecution's theory. And as to 801 pursuant hearsay, Your Honor, this is not hearsay, as this is not being used for the truth of the matter asserted, and as an offer of proof, Professor Van Owen, when identifying this exhibit, stated that this is a possible way that the knife could have been held. Therefore, this is an issue of weight, not admissibility, Your Honor.
If I may, Your Honor.
Very briefly, counsel.
In regards to the cumulative, under Rule 703, an expert witness is able to testify as to evidence that might not normally be entered in the whole court of law. Therefore, Professor Van Owen is able to testify as to the knife grip and the nature of the knife without this exhibit being entered. It is very capable of holding her hands in such a manner, showing how the knife could have been held without such evidence.
I'm going to go ahead and for demonstrative purposes only, allow these exhibits to be entered into evidence.
Yes, Your Honor. Now, Professor Van Owen, using Exhibit 21 and 21D as you see fit, can you please tell us your concerns with the prosecution's theory regarding the knife?
Yes. Now, you can see a little bit here, although it is obscured by the hand, but the underside of the handle is grooved for the hands to be able to better grip it this way, with the fingers around the more curved portion of the blade. Now, if it's held in this way, as you can see, the knuckles and the blade are both pointed downwards. If we were to change this position from a vegetable chopping position to a more overhead position like this, the knuckles and the blade would still be pointed in the same direction or upwards for maximum comfort and for it to be less awkward. Now, for the prosecution's assertions to be correct, the intruder would have had to hold the knife with the fingers around the flat part of the blade, which is just very unlikely as it's an extremely uncomfortable position. Instead, it's much more likely that the intruder held it in the fashion that I demonstrated earlier and stabbed downward into the victim's back.
Thank you, defense trial technician. Exhibit 21 on the screen is no longer needed. Now, Professor Van Owen, were there any other concerns with the evidence that was found at the crime scene?
Yes, as you saw earlier, the victim had a Ring doorbell system installed. This just means that he had cameras around his house that he was able to monitor from his phone. Now, there's the possibility with the system to be able to set up notifications. However, we won't ever know if the victim did have notifications set up because Detective Markowitz didn't pull the proper user account records from the victim's phone to know if this was the case. Now, even if we knew that the notifications were turned on, there's nothing to say that the victim had his phone nearby. And even if he did have his phone nearby, that he saw or acted on these notifications.
Professor Van Owen, based on all of this evidence and in your expert opinion, based on the prosecution's investigation, is Avery Becker involved in this crime? Is Avery Becker involved in this crime?
All of the evidence points. Sorry, seems to be a feedback issue. Am I the only one seeing that?
Mr. Rich had his mute button off, so I think he has repaired that. You may proceed now.
All of the evidence seems to suggest that this was an intentional homicide rather than a burglary gone wrong. If this is the case, then it doesn't make any sense for it to have been Avery Becker that committed this crime.
Now, Ms. Becker, I want to talk about the alibi that, Ms. Van Owens, I want to talk about the alibi that you mentioned earlier. Who is this alibi?
Well, Avery Becker was with Taylor Perkins on the day in question. They were looking for Avery's lost phone at the mall.
Did you do anything to confirm that Avery Becker and Taylor Perkins were looking for Ms. Becker's lost phone?
I did. I looked at all of the call detail records obtained by Detective Markowitz and saw that for all of the calls and texts received by Ms. Becker's phone, there were corresponding calls and texts sent from Taylor Perkins's phone, from the antenna that surrounds the area around the mall.
Professor Van Owen, based on this evidence and in your expert opinion, is it possible for Ms. Becker to be at the crime scene?
No, because there's evidence that backs up their story of being at the mall. She couldn't have also been at the scene of the crime on the day in question.
Now, Ms. Van Owens, let's talk about the alternate suspect. Who is the alternate suspect in today's case?
Her name is Blair Rollins. She's a student at Colorado High School with Avery Becker, Taylor Perkins, and Alexis Fuentes last year. She's about the same size and build as Avery Becker from what I've seen in the CHS yearbooks, and therefore the same size and build as the intruder seen in the Ring doorbell videos.
Professor Van Owen, is there any evidence that Blair Rollins has a motive to go after Mr. Brackman?
Yes, actually. Mr. Brackman attempted to defend Mr. Rollins, Blair Rollins' father, from a murder charge. Ultimately, Mr. Rollins was convicted and sent to jail, and at the sentencing hearing, which Blair was present for, Mr. Rollins threatened harm on Mr. Brackman. You can hear this in the exhibit that was admitted earlier in my testimony.
Your Honor, at this time, I move to publish Exhibit 22, which has been previously admitted into evidence.
It will be published.
Now, based on all of the evidence that you analyzed, is it possible for an alternate suspect to be involved in this crime?
Well, Blair Rollins, I conducted an extensive research into the whereabouts of Blair Rollins, and I could not find her. So based on this and Avery Becker's alibi, as well as the awful investigation, there's a high likelihood that an alternate suspect was involved in this case and not Avery Becker.
Thank you, Professor Van Owens. Thank you, Your Honor. I have no further questions.
Thank you, Ms. Melendez. Mr. Dinezad, do you have any cross-examination of this witness?
Yes, Your Honor.
Proceed.
Professor Van Owen, one of the reasons you quit the police force is because you became disillusioned with it.
And that's right. And now I make it my job to keep the police, to keep them accountable.
And this was because of an incident in which you were sued, correct?
And that's right.
And since that time, you considered yourself a bit of a crusader for social justice, isn't that right?
Yes, I consider myself a check on the police, so nothing happens to other police officers like it happened to me.
In fact, that's what you teach, social justice, correct?
That's right.
And you just testified that you've been endorsed as an expert a fair bit of times, as well as consulted on hundreds of cases.
Hundreds of cases, yes.
And all of those cases have been for the defense, correct?
Yes, I've actually consulted for the prosecution. I just haven't testified for them.
Nowhere in your statement does it say that you've consulted for the prosecution, yes or no?
No, it doesn't. I figured it was implied in my field of work.
Thank you. In each of these 100 cases where you consulted for the defense, you were paid for your opinions, correct?
I am paid for my work and my testimony, yes.
And isn't it true that if you don't find anything favorable for your client, you wouldn't get paid nearly as much?
I'm sorry, I'm not sure what you're asking.
Isn't it true that if you don't have sufficient evidence to bring to court, you wouldn't get paid as much for your findings?
I get paid for my time and my court testimony.
And that's between about $6,000 and $10,000 per case, correct?
That's right.
Now, let's move on to your investigation. You were retained to review the police's investigation, isn't that right?
Yes, I reviewed the detective's report, the crime scene reconstructionist report, all of the evidence, and I even conducted my own partial investigation.
And your job was to find something wrong, correct?
And my job was to make sure they did an adequate job, and as we've seen, they didn't.
So yes, your job was to find something wrong.
No, my job was not to find something wrong. My job was simply to review all the evidence and make sure that the prosecution's conclusions were accurate based on that evidence.
And now, isn't it true that you didn't visit the scene of the crime?
I had access to, again, all of the reports made by the detective and the crime scene reconstructionist, so it would have been of no help to me to visit the crime scene.
So that's a no to my question.
No.
You didn't take any pictures on the scene, correct?
Again, I had access to all of the evidence and exhibits in today's case, so I had no need to.
Professor Van Owen, I'd ask that you answer these questions with a simple yes or no. And you didn't view, at the scene of the crime, the body of Mackenzie Brackman, did you?
No, I did not.
But Detective Markowitz did, didn't he?
And preserved photos of this.
And so did Kyle Kuzak, correct?
I believe so, yes.
Now, let's move on. You testified that, in your opinion, Detective Markowitz may have neglected some potential evidence, correct?
That's right.
You think he should have obtained Taylor Perkins' cell phone records?
Yes, he should have.
And the complete Ring doorbell records?
Yes, that's correct.
But you never obtained that information, did you?
No, and that's a failing on my part. I should have. However, it shouldn't have fallen to me in the first place. It should have been Detective Markowitz's job to do that.
But nothing prevented you from obtaining this information, correct?
No, nothing did. And I agree that that was a failing on my part.
Now, it's your theory that Brackman was surprised in his house and stabbed in the back, correct?
Yes, all of the evidence points towards an intentional homicide rather than a burglary gone wrong.
You believe the intruder brought their own knife?
Correct.
You reviewed all of the images and videos provided by the prosecution for today's case, correct?
And that's correct.
And that would include the coroner's report.
I did.
As an expert, you relied heavily on both of these things, correct?
I did.
In the autopsy report, the incision was said to be approximately 7 inches long, correct?
Yes, I believe so.
Thus rendering the blade approximately 7 inches long.
Yes, it was pointed in the anterior direction, which means towards the head.
And this would mean that the knife itself, in addition to the handle, was about 11 inches long, correct?
Yes, that's correct.
Now, after reviewing the photos and videos of the intruder, there's no image of the intruder holding a knife that's about a foot long in length. Yes or no?
Not that you can see, however, the intruder is actually wearing quite baggy clothing and it could be hidden anywhere in those clothes.
Professor Van Owen, there's no evidence of the intruder holding a foot long knife. Yes or no?
No visible evidence. Yes.
Let's move on. Let's talk about Blair Rollins. You reviewed the audio tape from the trial of Jonathan Rollins, correct?
Yes, as well as the sentencing hearing.
And the speaker was Blair Rollins' father, Jonathan.
That's right.
And he made this statement as he was being escorted to jail, correct?
That's correct.
And it wasn't Blair Rollins who made this threat, was it?
Blair Rollins was present at the time, and I can imagine that Blair Rollins was distraught.
My question was not whether you believe Blair Rollins to be present. My question was that Blair Rollins did not, in fact, make this statement.
No, she did not.
And you reviewed audio tapes, correct?
And that's right.
Nowhere in your statement does it say you reviewed videotapes.
No, I did not.
Because there were no videos. So you yourself didn't see Blair Rollins in the courtroom, did you?
No, I did not.
Therefore, you have no personal knowledge about whether Blair Rollins was present when Jonathan Rollins made the threat to Mackenzie Brackman. Yes or no?
I actually do. Blair Rollins spoke at the sentencing hearing earlier, so it is very likely that Blair Rollins was still present at that time.
My question wasn't whether it was very likely. My question was if you have concrete evidence that Blair Rollins was present. Yes or no?
No, I don't have concrete evidence, and most of my work doesn't involve concrete evidence. It merely involves possibilities and probabilities and likelihoods.
Professor Van Owen, that's a no to my question, correct?
I have no concrete evidence, that's right.
Thank you. No further questions, Your Honor.
Thank you, counsel. Any redirect of this witness, counsel?
Your Honor, before I make that decision, may I inquire a brief time check?
Yes, you may. Could you post the current amount?
The defense has 14 minutes and 1 second remaining.
Thank you.
Given that, Your Honor, no redirect.
Thank you, Ms. Melendez. Next witness, Ms. Malloy.
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
Thank you.
And Your Honor, before I begin, the defense will be referencing Exhibit 15, which has been previously admitted. At this time, may I have permission for my trial technician to draw attention to the areas described by the witness using her cursor?
Yes, you may.
And can you see and hear me all right, Your Honor?
Yes.
Good evening. Would you please introduce yourself to the jury?
Good evening. My name is Taylor Perkins. I'm a freshman at CU Boulder, Go Buffs. And last year I was on the CHS mock trial team.
Now, Ms. Perkins, I'd like to start off by talking to you a little bit about Avery Becker's alibi. Were you with Ms. Becker on March 6, 2020?
I was, yeah. The two of us were looking for her phone. It was stolen the night before.
Well, why do you think her phone was stolen?
The day of March 6th, Avery and I spent the entire day looking for her phone. We went to every possible place it could have been. We went to the mall, we went to the fry shack, but after not being able to find the phone in any of those places, we thought it might be stolen.
Could you clarify where precisely you went while you were looking for the phone?
Sure. We basically retraced our steps from the night before. So first we went to the mall, we walked around some of the stores we went into, and then when we couldn't find the phone, we went to the fry shack to check with the afternoon shift change.
Your Honor, at this time, may I have permission for my trial technician to display Exhibit 15 on the screen?
You may.
Ms. Perkins, using Exhibit 15, can you describe for the jury where the mall is?
Of course. If you follow Highway 36, which kind of cuts down on the right side of the exhibit, you can see the number 36. And right below that, where the timekeeper's cursor is the words mall. That's where I was with Avery Becker.
And could you tell us where the fry shack is that you were talking about?
Sure. If you go back to where the mall is, and then go down and a little bit to the left, you can see the words fry shack. They're a little small, but that's where I was.
Thank you. My timekeeper may stop displaying Exhibit 15. We are finished. Ms. Perkins, What time did you go to the Fry Shack?
I don't know the time precisely, but I know it was in the afternoon.
Why is that?
For one, we spent the whole day looking for her phone. So by the time we were done walking around and looking for it in the mall, it was pretty late in the day. But also, we went to the Fry Shack specifically for the afternoon shift change. We were hoping that maybe somebody was working there that night who had worked the night before and had seen the phone.
Did you ever find the cell phone?
No, we never did.
Next, I'd like to talk to you a little bit about the awful investigation. Earlier in the trial today, there was some evidence about how the detective failed to contact key witnesses. Did the police ever contact you?
No, they never did. I never heard a thing from the police. The only people I heard from were you guys. It's deeply concerning that they never reached out, considering I was with Avery the whole day.
Did the police ever ask to see your phone?
No, they never did.
Now, lastly, I'd like to talk to you a little bit about the alternate suspect in today's case, Blair Rollins. Do you know Miss Rollins?
Yeah, Blair and I went to high school together. She's a year younger than me, so when I was a senior, she was a junior. I saw her around school sometimes.
Did Miss Rollins have any friends at Colorado High School?
She did. She and Alex Fuentes were really good friends.
When was the last time you saw Blair Rollins?
It must have been sometime last year. Not since all of this happened, though.
Just to clarify, have you seen Blair Rollins since March 6, 2020?
No, I haven't. I don't know anyone who's seen or heard from Blair since she went missing that Friday, March 6th, the day Mackenzie Brackman died.
Thank you, Your Honor. I have no further questions at this time.
Thank you. Any cross-examination of this witness?
Yes, Your Honor. Ms. Perkins, you gave a witness statement in this case, correct?
I did.
Isn't it true that you talked to Avery Becker before giving this witness statement?
Yeah, I talked to Avery a lot. I'm not quite sure which time you're referring to.
Actually, you talked to Mr. Becker twice before ever writing anything down, correct?
I talked to Avery numerous times, like I just said. She and I met after her lawyers approached me, if that's what you're referring to.
So you and the defendant were close, right?
Yeah, we were friends.
And if she was in trouble, you would want to help her out, right?
I'm not quite sure what you're insinuating. Avery and I were friends. That's about the extent of our relationship.
Yes or no, Miss Perkins. If Avery Becker was in trouble, you would want to help him out, correct?
I can't say that with a yes or no. I'm definitely here testifying today because Avery didn't kill Mr. Brackman, because I was with her the whole day.
On multiple occasions, you made sacrifices to help Avery, right?
I wouldn't say multiple occasions, but I did step down from the mock trial team for Avery.
Right, so you stepped down so that Avery could get his spot back, and then you also skipped school on a whim to help him find his phone, right?
Yeah, I did that.
So on March 5th, you were with the defendant at the Fry Shack, correct?
Yes.
And the defendant had his phone.
She did.
And she was very attached to that phone, right?
Yeah, she was kind of addicted to it. Sometimes I would say it was like her third kidney.
So she was addicted to it, but you also say she forgot it once at the table at the Fry Shack and again when you two actually left the Fry Shack?
Yeah, and it's good that you mentioned that because it really speaks to how distraught Avery was at the time. We were talking to people at the Fry Shack who were former mockers, and she got really upset. And so it's really interesting to see how upset she was because she left her phone on the table.
Thank you, Ms. Perkins. So after you left the Fry Shack, you two went to the mall, right?
Yeah.
And you testified that you don't know if the defendant had her phone with her while you guys were at the mall, correct?
That's true. We realized the phone was missing the next day.
So it's your testimony that the entire time you were at the mall, Miss Becker never checked social media, texted her friends, or called her mom?
No, because she didn't have her phone.
Right, because if her phone was really missing and she had tried to do even the smallest thing, she would have noticed, correct?
I'm not quite sure what you're asking. Avery's phone was missing, and then later on March 6th, we went to go look for it.
You just testified that Miss Becker was addicted to her phone. It was like her third kidney, correct?
Yes, I have said those words.
So let me confirm, it's your story that she didn't notice her phone was missing when you guys left the Fry Shack, when you went to the mall, and when she went home. That's your testimony?
Yeah, like I said, it shows how distraught she was.
Thank you, Ms. Perkins. And then the next morning, she got up, she got ready for school, and she drove to meet you, and still didn't notice her phone was missing until you said something. Isn't that correct?
Not necessarily. Yes, I did mention that her phone was missing, but she could have known it was missing before that. I just happened to get into the car and immediately ask, "Where's your phone?"
So, Ms. Perkins, do you recall giving a witness statement in this case?
I did.
And you had the opportunity to change that statement up until the court today?
Yes.
Now, in that witness statement, you state that when I mentioned something, we both realized that her phone was missing, correct?
I said when I realized it was missing, when I said something about it, we realized it was missing. Yes.
So that means that you both realized it was missing when you said something, correct?
That's when we realized it at the same time. Again, it was all part of the conversation we were having together.
So if you realized it at the same time, that means that Avery Becker couldn't have known it was missing beforehand.
I still don't agree with you. I mentioned it when I got in the car. Avery could have known when she woke up that morning. You'll have to ask Avery.
So you testified that you think Blair Rowlands could have been involved in Coach Brackman's death.
Yes.
It was Avery that came up with this idea, wasn't it?
She mentioned it, yes.
So you testified that you and Miss Perkins were driving around. You were nowhere near Coach Brackman's house.
On the day of March 6th?
Yes, ma'am.
Yes, the two of us drove around town looking for her phone. We went to the Fry Shack, and the mall.
If you could answer my question, you testified that you were nowhere near his house, correct?
I don't know where Mr. Brackman lives, so I can't say for certain.
Ms. Perkins, in your witness statement, you did say that you and Miss Becker were nowhere near Coach Brackman's house, correct?
Yeah, we were at the Fry Shack and the mall.
So you were at Coach Brackman's house on Friday, March 6th?
No, I just said we were at the Fry Shack and the mall.
And you're sure about that, Ms. Perkins?
Yes, I'm quite sure.
And do you recall in that witness statement saying it was creepy to think about Brackman bleeding on his porch?
Yeah, when we were at the Fry Shack, we ran into some old mock teammates, and they're talking about how Brackman didn't show up at practice. When I wrote the witness statement, I had known that Mr. Brackman had died. So yeah, it was weird to think that that was happening.
The unknown 911 caller also said that Coach Brackman was on his porch, correct?
Yes.
So you and this unknown 911 caller have identical, incorrect accounts of where Coach Brackman was found. Yes or no?
I don't know. I didn't hear about any 911 caller until today. I simply told you what I knew in my witness statement at the time.
Ms. Perkins, didn't you just testify that you do know that the 911 caller also said he was on his porch?
Yeah, but at the time that I wrote my witness statement, I didn't. That was the first time that I heard of it today.
Thank you, Ms. Perkins. No further questions.
Thank you, Ms. Dino. Any redirect of this witness?
Before I begin, may I request a brief time check, Your Honor?
Certainly. Can we have a brief time?
Yes, the defense has 9 minutes and 53 seconds remaining.
Proceed,
Based on
counsel.
that, incredibly briefly, Your Honor, may I have a moment to readjust my virtual courtroom?
I'd prefer that we keep this moving so that the trial can move on. So please proceed.
Yes, Your Honor. Ms. Perkins, did the fact that you were Ms. Becker's friend have any impact on what you testified to today?
Absolutely not. I'm here today telling you what happened on March 6th. I just told you that I was with Avery Becker at the Fry Shack and at the mall. I don't know how many times I can say this. That's what happened.
And when did you learn of the 911 caller's testimony?
A couple minutes ago when Detective Markowitz was talking about it. That was the first time.
Thank you, Your Honor. I have no further questions at this time.
Thank you, Ms. Malloy. The witness is excused. Does the defense have another witness?
Yes, Your Honor. The defense calls Avery Becker to the stand.
Thank you.
And
Proceed.
before I begin, can you hear and see me all right?
I can certainly do that. You may proceed.
Good evening. Would you please introduce yourself to the jury?
Hi, my name is Avery Becker, and that's Miss Avery Becker for Detective Markowitz's information. I should be a freshman in college this year, but I've had to put my life on hold for something I didn't do. I just want to look y'all in the eyes and tell you the truth.
Have you been present for the testimony from all the witnesses today, Miss Becker?
Yes, ma'am, I have.
And did you kill Mr. Brackman?
No. He was my mock trial coach, and I never could have hurt him.
Let's discuss the prosecution's investigation in today's case. Based on your perceptions and observations and everything you've heard from this trial, how would you describe the investigation into what happened to Mr. Brackman?
Objection, Your Honor, lacks personal knowledge.
Any response?
Yes, Your Honor, this does not lack personal knowledge. The witness just stated that she has been present for all the testimony from the witnesses today. She is also the one that the investigation was directed at. She has the knowledge to testify as to how she believes the investigation went.
The objection is sustained. Please move on.
Yes, Your Honor. Now, we just heard from Taylor Perkins that she was never interviewed by the police. Do you know of any of your friends who were?
No, not that I know of.
Were your parents ever interviewed by the police?
Not that I know of.
Did the police ever search your house for evidence?
No, but I wish they would have. Detective Markowitz could have seen I didn't have my phone or anything else related to this crime.
Earlier, we saw a video of the murderer caught on camera by Mr. Brackman's Ring doorbell. Is that you in the video?
No, I was at the mall all day with Taylor, and it's not like I can be in two places at once, but it easily could have been Blair Rollins.
Objection, Your Honor.
Yes, counsel? You have an objection?
Yes, speculation to the comment that it could have been Blair Rollins. She is speculating that the person in the doorbell would be Blair Rollins and would have this is an improper lay opinion and speculation on this matter.
Counsel, do you have any response?
Yes, Your Honor. My witness did not testify that it was, in fact, Blair Rollins. She said it could have been Blair Rollins. That is rationally based on her perceptions and observations from everything she's heard in the trial today, pursuant to Rule 701.
The objection is overruled. You may proceed with the question.
Now, have you ever been to Mr. Brackman's house?
No, I don't even know where he lived.
Well, let's talk about the prosecution's evidence that they presented against you today. Did you send the text messages to Alex Cifuentes?
No, I never even seen those texts before today.
Would you ever send text to Alex?
No. Even though we were on the same mock trial team, Alex and I never really got along. He was always going after the roles that I got, and I never got the feeling that he liked me very much. I didn't think to reach out to him because I didn't think he'd help me.
Could the text that Alex Cifuentes claims to have received come from your phone?
Not from me. Not while I had it. There's just no way.
We heard Mr. Cifuentes testify that you threatened to trash Mr. Brackman's house. Would you ever do that?
No. After the car incident, all I wanted to do was apologize, get back on the team, finish out my senior year in mock trial. I even went to his office to try to apologize, but he was murdered before I ever got the chance to say I'm sorry.
Mr. Cifuentes also testified about the car incident. Is there anything you'd like to tell the jury about that?
The same thing I wish I could have told Mr. Brackman. That I regret it. It was dumb, the worst thing I've ever done. And that I'm sorry.
Well, let's talk about the reason that we know you didn't commit this crime. Your alibi. Do you remember what you were doing on March 5th, 2020? 6th of 2020, excuse me.
Yeah, of course. It's one of the biggest reasons I can't believe they're accusing me of doing this. I was at the mall all day with Taylor, like she just said.
Well, in your own words, why were you with Miss Perkins?
We were looking for my phone. It had just been stolen the day before.
And since we just heard from Miss Perkins, we'll skip going over all the details again, but to confirm, did you ever find your phone?
No. And over the past year, I thought maybe Alex took it.
Objection, Your Honor. Speculation.
May I respond, Your Honor?
Yes.
Your Honor, this is not speculation. It is rationally based on the witness's perceptions and observations of everything that's happened over the past year. Furthermore, she is about to lay that foundation as to how she knows this, or why she thinks this, rather.
Any response?
Yes, Your Honor, she cannot speculate that Alex Cifuentes took her phone. She can have no knowledge of that and can't testify to someone else's actions or knowing what he did, and therefore is speculating in this case, and no foundation can be laid for her to make that statement.
May I briefly respond, Your Honor?
What I'm going to ask you to do is lay a better foundation as to Ms. Becker's knowledge.
Of course, Your Honor.
Your Honor, for the time being, can we strike that testimony from the record until the foundation has been laid?
I'll consider that by the time the foundation is laid. Proceed, counsel.
Ms. Becker, you mentioned that your phone was missing. When was the last time you saw it?
It was March 5th of 2020. Taylor and I were at the Fry Shack when Alex and some of the other mock kids came in. Like Taylor said earlier, they were all talking about, mock trial, and I got upset because I'd been kicked off the team. And so I went to the bathroom to cool down. When I came out, I just left. There's plenty of time for Alex to take it.
Did you?
I re-raise the speculation and objection.
That objection will be sustained. Counsel, please move on.
Yes, Your Honor.
Stricken from the record both what she just said and what she said earlier.
It is so stricken.
Now, Ms. Becker, is it possible that you could have had the time to commit this crime without Taylor Perkins knowing?
No. Taylor and I were together all day.
Let's discuss the alternate suspect, Blair Rollins. Do you know Blair?
Kind of. We went to school together, but we weren't real close.
Could you describe what Blair was like for the jury?
Well, everybody knew that Blair hated Coach Brackman.
Objection, Your Honor. Improper character evidence.
May I respond, Your Honor?
Yes, please do.
Your Honor, this is not improper character evidence pursuant to Rule 404. We're not using this to show that that Blair Rollins acted in accordance with any character trait. Rather, we are using it to show motive. Ms. Becker will testify in a moment as an offer of proof why Blair Rollins hated Mr. Brackman, and that will go to show motive, which is a permitted use under Rule 404B.
Any response?
Yes, Your Honor. My objection is under 404A. In this case, the opposing counsel is trying to offer the character trait of hate that Blair Rollins had for Mr. Brackman, and that he acted in accordance with that on March 6th as an alternate suspect in this case. And this therefore is improper character evidence because they are trying to say that he acted in accordance with this trait on this date and acted in accordance on a later date. And she also does not have the personal knowledge to testify about what Blair Rollins thought or who he hated.
I'm going to allow the witness to testify, but on a very short leash. Go ahead and proceed, counsel.
So, do you know why Blair hated Mr. Brackman?
Well, Brackman was a criminal defense attorney, and like Professor Van Owen said earlier, he represented Blair's daddy on a murder charge, but Mr. Brackman lost the case. Blair's daddy went to jail.
Could you describe Blair's height and build for the jury?
We were about the same height and build. Anyone seeing the two of us walking away could confuse us.
So, is it possible that it was Blair Rollins in the video from Mr. Brackman's Ring doorbell?
Objection, Your Honor. Speculation.
That is sustained. Move on, counsel.
Yes, Your Honor. When was the last time you saw Blair Rollins?
It had to have been sometime before all this happened, but I can't be sure exactly when it was because I only really saw Blair in the hallways at school.
If you weren't friends with Blair, how is it possible that Blair could have had your phone?
Objection, Your Honor. The foundation has not been laid that Blair had her phone, so this question cannot be asked without the foundation being laid beforehand.
May I respond, Your Honor?
Yes, but very briefly.
Yes, Your Honor. As stated in opening and many of the directs and crosses, it is the defense's theory of the case that Blair Rollins was the one in possession of Avery Becker's phone as it traveled along that route laid out by Detective Markowitz. The foundation has been laid to show that it is possible that Blair could have had the phone through testimony from all the other witnesses.
And your question is what?
My question was, how is it possible that Blair could have had your phone?
I'll allow the question. Go ahead. Please answer.
Would you like me to re-ask the question?
No, I remember it. Blair could have gotten my phone because Blair and Alex were best friends.
Objection, Your Honor. Speculation. What was just ruled that Alex took Miss Becker's phone, that was ruled and sustained that was speculation. So it would be further speculation to say that Blair Rollins Alex Fuentes gave that phone to Blair Rollins.
I will sustain that objection.
And move to strike that testimony from the record, Your Honor.
No testimony was testified to at this point with regard to that. Go ahead. Next question, counsel.
Yes, Your Honor. Now, Ms. Becker, you testified that you haven't seen Blair since before Mr. Brackman's murder. Do you know if any of your friends have?
No, not that I know of.
Speculation. She doesn't know what her friends have seen before and therefore would be speculating on everything that they've seen in the past.
That objection is overruled. Please proceed.
Now, Ms. Becker, did you go to Mr. Brackman's house on March 6th of 2020?
No, I was at the mall with Taylor looking for my phone.
Thank you, Ms. Becker. Thank you, Your Honor. I have no further questions at this time.
Cross-examination of this witness.
Yes, Your Honor.
Please proceed.
Now, Ms. Becker, you thought you were the best person on the mock trial team.
I mean, I was definitely good at it, yeah.
And you wanted to win awards at state, didn't you?
Of course. Who doesn't?
But Mr. Brackman stood in your way.
No, I wouldn't have been able to get to state without a coach.
But he did stand in your way because he kicked you off the team.
He did, but he did kick me off the team, yes.
And you thought he hated you.
It seemed like that.
He called you lazy?
Sometimes, yes.
He criticized your work?
That's correct.
And he even moved you down to the B team.
Yes, ma'am.
And then, after all of your accomplishments, he said you only won because of your looks.
He said that, yes, ma'am.
And this made you very angry.
At the time, yeah, it did.
So you went outside and wrote Worst Attorney Award in permanent marker on his car.
I didn't know it was a permanent marker, but Yes, ma'am, and I regret doing it.
And then after that, you went home and you talked to your mom, didn't you?
Yes, ma'am, I did.
But you didn't tell her the real story.
I left out some parts, but I didn't lie to her.
You actually blamed your actions on Mr. Brackman.
I don't quite understand what you're talking about.
You blamed you getting kicked off of the team based off of Mr. Brackman's anger, not your own actions of writing on his car, didn't you?
I said something along those lines, I guess.
And you told your mom that you would get back at Mr. Brackman if it was the last thing you did.
That night, I was upset. So yes, ma'am, I said things that I never intended. I'd never followed through with.
And you heard Alex Cifuentes say that you texted him that you would wait until Mr. Brackman was at work, then break into his home and trash it.
I heard him say that, but it's a lie, ma'am.
Except those statements are similar to what you told your mom, aren't they?
No, ma'am, I wouldn't say they are.
Objection, Your Honor, may I be heard?
Yes.
Opposing counsel is comparing an act of anger when Ms. Becker said something to her mother to the text messages. She's using this to prove that Ms. Becker acted in accordance with a character trait of anger towards Mr. Brackman. And because she's comparing these two different traits, these two different instances, she's using them to show that she acted in accordance with that trait, which is improper under Rule 404A.
Counsel, Ms. Seaman?
It's the defense's theory that Ms. Becker didn't send these text messages. I am merely showing the similarities between these text messages and what the defendant said to her mother to show that the defendant did actually send these text messages. I'm not going to show that she acted in accordance, rather to show that she actually sent these text messages and is here lying about it.
Counsel, refresh my recollection, but I'm not quite certain the text messages were introduced into evidence. Is that correct?
Not the actual text messages, but Mr. Cifuentes testified on what she said in these text messages. And during her statement or during her direct examination, opposing counsel asked her directly from these text messages what they said, and therefore evidence and testimony has shown what these text messages said.
I'll go ahead and allow a little further leeway, counsel, but very little.
Yes, Your Honor.
Proceed with the witness.
Yes, Your Honor. It's also your story that you lost your phone on March 5th, isn't it?
It's not a story, ma'am. It was stolen that day.
But your phone is very important to you.
I liked my phone, if that's what you're asking.
And you heard Taylor Perkins say it's like your third kidney.
I guess to her it might seem like that, but it's not really.
And you joined mock trial to be on that phone longer.
I joined mock trial to spend time with my friends and get out of the house, ma'am.
And to text Taylor across the room.
No, ma'am, that was not why I joined mock trial.
But your mom took your phone away every night, didn't she?
Until I got my homework done, yes, ma'am.
Objection, Your Honor. May I be heard?
Yes.
I object to the relevance of this line of questioning. Whether or not Ms. Becker's mother took away her phone does not tend to prove or disprove any issue in this case pursuant to Rule 401.
The objection is sustained. Counsel, please move on.
Yes, Your Honor. And you didn't notice your phone was missing when you turned your phone in that night, did you?
When I don't quite understand what you mean by that question.
And your phone was missing at the Fry Shack, at the mall, and when you got home on March 5th, wasn't it?
Yes, ma'am.
And it's your story that you skipped school on March 6th to find it.
It's not a story, ma'am. That's what I did.
You went with Miss Perkins, your best friend, didn't you?
Yes, ma'am, I did.
Miss Perkins, who joined mock trial for you?
We thought it would be fun to do it together. Yes, ma'am.
You quit mock trial so you could get back on the A team?
That was her choice, but yes, ma'am.
This person, your best friend, is the only person who knows where you were on March 6th.
If Detective Markowitz would have looked into it, he'd know it too. But as it stands, yes, ma'am.
No further questions, Your Honor.
Thank you, counsel. Any redirect?
First, may I inquire as to how much time I have remaining?
Yes, you may.
The defense has 2 minutes and 30 seconds remaining.
Yes, Your Honor. No, Ms. Becker, excuse me 1 second. Ms. Becker, did you mean your statement about getting back at Mr. Brackman?
No. That night, I was upset I got kicked off the team. And so I told my mother that, but I'd never follow through with it. And after I said that, my mama set me straight, and I knew I had to apologize, which is what I tried to do.
No. Did you convince Taylor Perkins to do anything for you?
No.
Thank you, Your Honor. I have no further questions.
Thank you, counsel.
And at this time, the defense rests.
Thank you. The witness is excused. Are the parties ready for closing statements at this time?
Yes, Your Honor, the people are ready to proceed.
You may proceed.
And just to check, the people are wondering if any remaining time on closing be reserved for rebuttal.
You may reserve it.
Thank you, Your Honor. Thank you for your time and attention during the trial today. Everyone has a breaking point, and Avery Becker is no exception. After an endless barrage of criticism, insults, hatred, and a demotion from her mock trial coach, Mackenzie Brackman, she hit her breaking point. And in her own words, she would get back at Mr. Brackman if it was the last thing she did. And that is why we are here today. The evidence and testimony presented today has shown that Avery Becker, while attempting to vandalize Mr. Brackman's home, was surprised by his presence. She then fought him for control of his knife, consequently stabbing him in the back, leaving him to die in a pool of his own blood. Now, did she intend to kill him beforehand? It doesn't matter. What matters is she broke into his home, and now he is dead. The defendant has been charged with 2 crimes, first-degree murder and second-degree burglary. To be guilty of first-degree murder, the prosecution must have proven beyond a reasonable doubt the defendant knowingly and unlawfully broke into the residence of Mackenzie Brackman and during that invasion killed him. To be guilty of second-degree burglary, the defendant must have broken into this residence with the intent to vandalize. Now, the prosecution has proven these elements beyond a reasonable doubt. And as you deliberate, I want you to pay special attention to jury instruction number 8, because the defendant did not have to intend to kill him beforehand to be guilty of murder. Now let's walk through these. First, the defendant had clear motive to break into Mr. Brackman's house. She explained how important mock trial was to her and how the one person who stood in her way was Mr. Brackman. You heard about their tumultuous relationships, the fights and the cruelty that led up to her vandalizing his car. She snapped. And when she was finally kicked off the team for good, she decided to get revenge. She hit her breaking point. Now, with that motive in mind, let's look at intent. First, Ms. Becker talked to her mother, where she stated that she would get back at Mr. Brackman if it was the last thing she did. Then she texted Alex Fuentes in a final effort to get back on the team, again stating she would get back at Mr. Brackman by saying she would wait until he's at work, then break into his home and trash it. Those are intent. And so she established a false alibi with her loyal best friend Taylor Perkins, skipped school, went to Mr. Brackman's house, and killed him. Now let's talk about this alibi. You heard about Miss Perkins and Miss Becker's unwavering friendship. Miss Perkins joined mock trial, quit mock trial, and would have done anything for the defendant. She even talked to the defendant 2 separate times before giving her statement in today's case. Her statement is inherently biased and unreliable. And the story about Miss Becker losing her phone, a phone that was like her second kidney, well, that story is just not credible. Now, Miss Becker also had the opportunity. Detective Markowitz and Kyle Kuzak explained how all the evidence pointed towards Miss Becker and how the call detail records put her at the crime scene at the time of the murder. Now, the defense wants you to believe that this is about an alibi, that this is about an awful investigation. Well, that is simply not true. This alibi, we don't know if she was the 911 caller who called in Mackenzie Brackman's death. About this awful investigation, Professor Van Owens, all of her biased opinions are based on not one of her own personal observations. The defense fails to acknowledge the anger that lies dormant below Avery Becker's surface. Now, as you deliberate today, I want you to think of Mr. Brackman, a man who spent his life fighting for justice. Do not let justice fail him today. Avery Becker reached her breaking point, and there must be consequences. The people asked that you find the only logical verdict, guilty. Thank you.
Thank you, Ms. Seaman. Ms. Karen or Ms. Melendez, do you have a closing for me?
Yes, Your Honor, but before I begin, I have a request for the court. Earlier, my co-counsel asked if we were allowed to refer to jury instructions. And as that has been granted, is it possible I asked for permission for defense trial technician to display the jury instructions as I talk about them during my closing argument and in Exhibit 15, which has been previously admitted and published into evidence.
That's an unusual request, Ms. Melendez. What will the observation of the jury instructions tend to show here?
I will refer to the jury instructions and the specific language of the jury instructions as they will be put on the screen for demonstrative purposes, as that also applies for Exhibit 15, Your Honor.
I'm going to deny your request. Please go ahead and proceed with your closing.
Yes, Your Honor. May it please the court. Avery Becker is not guilty. That much should be very clear at this point. Avery Becker did not break into Mackenzie Brackman's house. She did not trash his house, and she did not kill anyone. The truth is in the alibi, the alternate suspect, and the awful investigation the prosecution put forth. Keep these in mind as the court gives you a set of jury instructions. These instructions tell you that up until this moment, and until you decide that Avery Becker is guilty, she is innocent. These instructions tell you that the prosecution must prove each and every single element of their charges beyond a reasonable doubt. Now, the concept of reasonable doubt exists because as Americans, we want to make sure, we want to be absolutely certain that no innocent person is ever convicted for a crime that they did not commit. An unjust conviction is intolerable and inexcusable under our system of fairness and justice. That is why the definition of reasonable doubt states that reasonable doubt is such a doubt as would cause a reasonable person to hesitate to act in matters of importance to themselves. And what is critical in that definition is the word hesitate, as mere hesitation to act is reasonable doubt. And ask yourself, how can you not have reasonable doubt after everything that you have heard today? At the beginning of this trial, my co-counsel asked you to keep in mind 3 important questions. What time did the victim, Mr. Brackman, actually pass away? The prosecution doesn't know. And where has Blair Rollins been since March 6th of 2020? The prosecution doesn't know. And how can Avery Becker be at two places at once? Again, the prosecution doesn't know. So when it comes to all of these critical questions, the prosecution just doesn't have answers for you. So if they don't know and we don't know, how can you be expected to know? And most importantly, how can you convict? The prosecution has talked an awful lot about how everyone gets to their breaking point. They're right. The prosecution's breaking point was ignoring the clear alibi. The prosecution's breaking point was ignoring the alternate suspect. And the prosecution's breaking point was the awful investigation that came at the ignorance of Detective Markowitz and Mr. Cusack. Their breaking point is the reason why Avery Becker is on trial today. So let's talk about the alibi that the prosecution ignored. One of the most crucial reasons that you cannot find Avery Becker guilty is because Taylor Perkins is her alibi. On March 6th, they were looking for Ms. Becker's lost phone the whole day. And Professor Van Owen has talked about the CDR data that corroborates this testimony. And let's not forget about the alternate suspect in today's case, Blair Rollins. Blair Rollins matches the height and build of the perpetrator seen in the Ring doorbell videos. Blair Rollins has a motive to go after Mr. Brackman. Mr. Brackman failed to get Jonathan Rollins off of murder charge. And therefore, Blair Rollins has a motive to go after Mr. Brackman. Blair Rollins hasn't been seen since the day of March 6th. All of this evidence pointing to an alternate suspect, it was completely overlooked. And then there was the prosecution's awful investigation. If you are sitting here frustrated, second guessing the answer to all of these questions, imagine how Avery feels. Assumptions lead to awful investigations. In this case is riddled with assumption. The prosecution assumed that the phone was on Ms. Becker. They assumed that her phone was in the vicinity of Mr. Brackman's house, and they assumed that she would sabotage her own efforts to get back on the mock trial team. The prosecution's storyline makes no sense. Avery Becker has admitted her faults. She is human, like all of us. We all wish we hadn't done immature acts. Ms. Becker admits she could have handled her confrontations differently, but it ends there. Don't convict Avery Becker because of the prosecution's breaking point. Find Avery Becker not guilty. Thank you.
Thank you, counsel. This concludes, oh, actually, you do have rebuttal time, I understand. Do you have a rebuttal, Ms. Seaman?
Yes, Your Honor. May I request a brief time check?
Sure.
35 seconds remain.
Thank you. Proceed, Ms. Seaman.
A biased alibi. Taylor Perkins has the same wrong story as the 911 caller. Is she a suspect? The alternate suspect. Avery Becker has blamed others for her actions before, and that is what she is doing today with Blair Rollins. An awful investigation made by the biased Professor Van Owens. She is a crusader against police. Her testimony is inherently biased. This case is about Avery Becker's breaking point. Find her guilty. Thank you.
Thank you, counsel. Thank you all for your presentations. Well done. Let's go ahead and give the panelists time to tally their numbers and submit their score sheets before we proceed with any kind of comments. And panelists, as you, once you have submitted your score sheets, please unmute yourself and come on video. And to you, the team members, you may go ahead and turn your videos on. So am I seeing all the panelists here? Yes, I see Mr. Rich and Ms. Hamburger. I am not seeing my third panelist. Where are you? To the courtroom monitor, do I not have a third panelist?
I am looking for them currently. I'm not seeing them in the participant list. But we did receive their score sheet. I can confirm that.
So you do have.
We do have all score sheets. Let's proceed with remarks and I'll try and locate our third panelist.
Thank you. So first of all, I'd like to congratulate both teams. You did an absolutely excellent job. I've been involved with the mock trial program for, well, long before any of you were born. So something like 1995, so a long time. And I've done everything from being obviously a presider, but also a panelist, an organizer, a recruiter, a coach, a speaker, just about everything, including writing cases for the mock trial program. And I think that this is an absolutely phenomenal tool that students and the community use to promote the practice of law, the understanding of the court system, and develop very unique skills in some absolutely phenomenal students. So thank you for being members of your team and for making the time and providing the dedication that is required. So I thank you for that, as well as thanking the panelists for putting of their time in the process. But more than anybody else, I'd also like to thank not your teachers, your coaches, your supporting family members. Without them, you couldn't be doing this in participating in such a great program. And obviously, thanking the Colorado Bar Association for dedicating so much time, effort, and commitment to a program that is, as I say, fabulous. So with that, my background, I've been a judge for 3 years. Before that, I was a litigator, and I've seen a lot of different attorneys making presentations. I'm always astounded by the quality of the presentations that I see in state mock trial programs and even nationals. Some of your performances are national quality. So I hope you all do well in the competition and move forward. And I wish you a lot of luck. So, Mr. Rich, would you like to make comments to the team members?
First, this is usually not my position because usually they have the old person start first, but I guess in this case, I am the old person. I'd like to congratulate you all. You've all done a great job. It's clear why you made it to the state competition from the regionals. I'm a 20-year litigator. I do civil litigation around construction, personal injury, and those types of matters. And as part of my work, I've been involved in setting up and instructing trial school is what we call it. And basically what we do is the same thing you're doing here. We create a mock test, a case, and then we teach young lawyers the skills that you've been learning. And it's clear that you have a high level of skills. There are young lawyers who've been out of school, 3, 4, 5 years, who you are on par with easily. So I commend you about that. I'm going to give some criticisms, just because I want to see you improve, and telling you all what great people you are doesn't help you improve. Although I think I will point out some highlights, I thought. So first of all, there is no objection may I be heard in the courts. There's objection hearsay, there's objection speculation, there's objection character evidence. There's no objection may I be heard. So, make your objection and say what the basis of it is. As soon as you say objection, you're demanding to be heard. So just be heard. Offers of proof are unusual in objections, and try to keep them short. I caught you guys did a great job with your themes. The defense did a fantastic job of not only stating their theme, but stating it over and over again and using it with their witnesses. Might have been almost a bit much when you're telling a witness, okay, now let's talk about the awful investigation. Okay, let's talk about the alternative suspect. But you had a strategy, and you used it throughout the case. And that's what's important. You use your strategy throughout the case. The plaintiff, the prosecution, I'm sorry, I'm a civil lawyer. The prosecution's strategy or theme was everyone had their breaking point. I didn't see that carried through the witnesses. It was certainly carried through from the opening to the closing, but I didn't see it carried through to the witnesses as much. So maybe if you have a theme, do what the defense did and carry it through with all the witnesses, because then it really hammers it home. I never forgot what that theme was. With the prosecution's theme, I didn't continue to hear it, and so I lost it until it was brought up again in closing. During the direct examinations, I think that Ms. Seaman with Mr. Brinkerhoff, good looping techniques, good short questions, guideposts. Let's talk about the rest of your investigation. Good knowledge of the rules and responses to objections. You weren't thrown off. Let's see. Mr. Brinkerhoff, I liked the use of the hands, but there were some times when you'd always just use your hands so much. So just tone it down just a little bit. There were times when you used them very effectively, but there were times when it was just a little distracting. Ms. Malloy, I loved your body language during your opening. It was great. The way you used your hands wasn't distracting, and it was effective. When did the victim die? I judged at the regional, and I kept asking this question to myself: when did the victim die? I thought that was a good point that I hadn't heard before, and I judged 4 rounds at regional. Let's see. And Mr. Brinkerhoff, I thought you were very effective, by the way, when I wasn't distracted by your hands. Let's see. Mr. Halbrook, you love movies. The movie quotes were, yeah, that was something. Every answer included a reference to a movie title or a movie quote. Again, you don't want to do anything that's going to distract somebody. And so, I mean, it was fun, and you were a good witness, but that was a little bit distracting. Again, Miss Dino, is it Dino?
It's Dino.
Dino, great. I think you were really good at handling objections. Don't ask to move on, just move on. Let's see. Yeah. That was you did a good job though. I really like that. Ms. Carrington, I thought you did a good job with the cross-examination there as well. It was, there was, I think the attorneys just did really good with their directs and cross-examinations pretty much straight through. Mr. Janeza, you made the witness the star on your direct examination of Cusack. I almost forgot you were there, which was what you want to do with a direct examination. You asked a question, got out of his way. Asked a question, get out of the way. Mr. Dudzik, your analogy and how you explained it, I loved that. You know, the puzzle pieces and what you do. I thought that was fantastic. I thought you were really, really good. Ms. Melendez, on the cross-examination, he was slippery, but he gave you a gift at one point. He said that what he does is speculative, right? You don't, when you have a witness who's telling you what they're doing is speculative, hammer them with it. Speculative is not what you want an expert witness to say. And so, you know, when you're given a gift, you know, you unwrap it. Let's see. So I'm always interested in the Van Owen performance because in my reading of the problem, Van Owen is terrible, horrible witness. You made Van Owen likable. And so, Ms. Brennan, I commend you because, yeah, I hated Van Owen reading the problem, but you did a great job with Van Owen. You know, Mr. Janeza, you hit your few points. You know, you don't waste your time. You hit your few points and you got out. That was great. It was effective. And Ms. Melendez, you did a great job directing Van Owen. It was nice. So, Ms. Dino, I do not want to be on the other side of the table from you. I do not want to be in the witness stand when you're cross-examining me. I was scared. I'm scared for anybody who has to go against you. It's funny because sometimes when people talk fast, it's because they're nervous. For you, you use it as because you're aggressive. And yeah, I was kind of wondering why you started out with, you know, why they gave the statement, but you were very clear about, you know, this is why you started with how they gave the statement. Usually you don't mention a statement until somebody testifies inconsistent with it, but I like that. And I also hadn't heard of that 911 caller connection in any of the rounds before. So you guys did a good job in coming up with that one. Let's see, Ms. Malloy, you did great job directing Perkins with the short questions. And is it Buchin? How do you say your name?
Buchin.
Buchin. I loved your performance. It was great. Very well done. And Miss Feeney, well, golly, is that your voice?
Yes, I learned to speak in Tennessee, so yes, that is
okay. My I wasn't sure if that was real or if that was affectation, but it was great. And, you know, I mean, my mama set me straight. Oh my God. I practiced with a lawyer for 10 years who's from West Virginia. Now, you talk to her every day, you have no idea she's from West Virginia. You get in her courtroom and she just starts talking like this and just loves bringing out that Southern charm, and juries are suckers for it. So yeah, you did a great job. Miss Carrington, you had a really good direct, and then your redirect on her was great. Just, you know, hitting what's important. Closing was great because you guys both used your own the other side's theories against them. Mm-hmm. That's what you love to see, because you don't know what it is going in. So I know, Ms. Seaman, that you were writing stuff down during the trial, and you were saying, okay, this is what I'm going to do to use their theories against them. And Ms. Melendez, you were doing the same thing, right? You know, what's the breaking point? Okay, I'll use breaking point. And I think both of you were very effective in using the other side's theme against them and it shows that you can be very adaptive to the situation, which you got to use because trials never go the way you expect them to. And with that, I'll shut up. So thank you all. Great job.
Thank you, Mr. Rich. I appreciate it. I think that you made very, very insightful points. I appreciate it. Okay, who is next? Ms. Hamburger?
Yes, thank you, Your Honor. Well, I first want to start out by congratulating all of you. You did a really outstanding job. It was a pleasure to spend the last few hours with you and watching you perform. I think you all have a great mastery of this case. You've clearly spent a lot of time dedicated to this. I've been in your place before. I did mock trial in high school. I remember all of the long days and evenings and how much time is put into this. I also was the founder, team captain, president, and coach for my college mock trial team. And then I coached law school mock trial as well. So I've been doing mock trial for quite some time. And then I've been a panelist and scorer for a number of years in a variety of different capacities in Colorado. So some of the best performances that I've seen, just very impressive overall. In terms of my background, I've been practicing for 10 years. I started my career in the U.S. Attorney's Office for the District of Colorado, doing civil litigation. So that was a real pleasure. Definitely high stress, but very fun and rewarding work. I then moved on to private practice. I practiced water law here in Colorado, and then currently I'm with a nonprofit practicing wildlife law. So a varied career, and always fun to see what I hope some of you will choose to do, to choose to enter the legal profession. And maybe I'll see some of you down the line at a CBA event. In terms of feedback, I agree with what Greg has said. I will try to provide some additional feedback and some additional insight without rehashing what he has already said. And if it's okay, I will be a little informal. If I could address you all by your first names, mostly because I haven't written down your last names and I can't see all of them. So thank you for bearing with me. So Thomas, I thought your opening was really effective. Again, as Greg said, a really nice use of theme. I also appreciated that you raised the felony murder issue and explained what we needed to be looking for as we went through the testimony of the case. I also thought you did a good job of bringing forward the particular key items of evidence that you flagged for us. So I appreciated you bringing that out. Kate, I thought you did a nice job, again, with theme, with presenting the three holes in the prosecution's case. I liked the alliteration. I liked that you raised the burden of proof, and you did a nice turnaround of the prosecution's theme. Anna, in terms of your direct, I thought you had really good objection responses. I thought you made effective use of exhibits. I particularly liked, you were poised when the text messages were challenged. And I think you did a nice job laying the foundation for the cell tower exhibit. And I also thought you did a quite effective redirect. So nice job there. Dirksen, I thought you did a really nice job with your role. I thought you had just the right level of arrogance for your character. I thought you did a nice job with that, a good mastery of the facts, and you were able to convey the prosecution's case in a compelling way. And I particularly liked your explanation of the cell tower exhibit. Kate, I thought you had good objections, particularly regarding the text messages. You had very hard-hitting questions. I liked the fact that you highlighted some of the holes in the case, such as failure to interview key witnesses and, highlighting the alibi issue. I thought that was helpful, as well as the call detail records. I did notice that you didn't do a voir dire. I expected to see that. And it may be that, other teams have not been entering this particular or submitting this particular character as an expert. But that was something that, I expected to see, but did not. Leah, I thought that you did a nice job with the direct. I thought that, you got out the information that you needed to get out. Owen, in terms of your portrayal of a character that you have lots of experience with, since you are playing that in real life, I thought you did a nice job with that. And I liked the movie analogies. I'm sort of glad that, my video and microphone were off because I was giggling, in response to your performance. So I thought that was well done. Bridget, I thought you had really nice objections. The impeachment, I'm not sure it was necessary, but that doesn't really matter because it was well done. So I was looking at the process that you were going through, and you mastered the process of impeachment. So I thought that was well done, and you had good questions. Thomas, in terms of your direct, you asked good questions, and I agree with Greg. I didn't think about you, during your direct, which may not sound like a compliment, but it certainly is, because that's what you want to see during a direct, because the star, of course, is your witness. So I thought you did a nice job with that. Michael, I thought you were very enthusiastic. I thought, when you said if you want me to get scientific with you or whatever, yeah, we do, that's sort of why you were called. So I think you could dispose with that particular phrase, but overall, I think you had a good mastery of the facts. I thought you held your own on cross-examination. So you did a nice job with that. And I also liked your discussion of Professor Owen and sort of setting her up for failure, when the defense finally presented her. So I thought you did a good job with that. Pilar, I thought you were very responsive to what the witness was saying. A lot of times, attorneys will just sort of barrel through and they have their own idea of whatever they want to say, and they don't really respond to what the witness says, but I thought you did a good job of responding. And I also expected a voir dire from you, but in that case, it may have been that his credentials were so bulletproof that may not have proved worthwhile. And then Pilar, again, your defense direct of Professor Owen was, you did a nice job. I liked the knife. I think you did a good job getting that into evidence. And then Caitlin, I thought you were a very persuasive witness. You did a nice job. You were compelling, convincing, professional, etc. Thomas, you did a nice job with the voir dire. And I thought you effectively undermined her in some ways. And I liked your emphasis on concrete evidence, though, Caitlin, I will say you held up very well under questioning. Kate, I think you did a nice job with that. I thought it was a very effective direct. And Annika, you did a really nice job with that witness. You held up well under cross as well. And Leah, I think you did a nice job with impeachment and asked fine questions. And I'm getting close to the end. Thank you for bearing with me. Bridget, I really liked what you did in terms of asking questions. Again, you sort of faded into the background and really let Hannah shine. And Hannah, I have to say, phenomenal job, really. I felt like I was watching an Academy Award performance. It was really compelling. You were very empathetic, sincere. I just couldn't imagine you murdering someone. So nice job with that. And Anna, I think you did a really nice job. This was a hard witness to cross. You couldn't have gone in there and have been really aggressive with her. So I think you struck a good tone for the witness. You had a good demeanor and great objections. Not much got by you. So nice job with that. In terms of the closing, Anna, again, theme was good. Getting out the legal requirements, that's always important. So glad to see that. and glad to see you hitting on motive, et cetera. So nice job overall. And then Pilar, I liked how you started with the goal of the US justice system. Always nice to be reminded of that. I liked the fact that you highlighted the prosecution just doesn't know all of these different things. So I thought that was nice. And then a good turnaround of the theme from the prosecution. So on the whole, very nice performances. And I was glad to be able to see them. Thank you all.
Thank you, Joanna. Great comments by both panelists. I understand that our third panelist is no longer with us, but she turned in her score, so you don't have to worry about that. I do want to make just a couple of comments, not specific to each one of you, because you're probably done with today and want to move on to tomorrow's round of competition. But one of the things that I see that was happening with some of you is that you're forgetting to have, even though this is a virtual world, you still have to have eye contact. So make sure that you look at your cameras when you are trying to make your final points, emphasizing information. I think that is, and some of you did it very well. Some of you were clearly reading something. You want to avoid that the eyes, shifting and reading. You want to, this is state competition, this is not regional. So everybody should be at that level where we don't see that you're reading. But overall, as I say, great competition. I wish you all very, very well. And I'd like everybody to take off their mute buttons, and I'd like to give all of you a round of applause. There you go. Thank you all.